Welcome, everybody. Welcome. I don't mean to interrupt. I just wanted to say, on behalf of the American Enterprise Institute and EPPC, I just wanted to say informally welcome. We're not starting yet. This is my announcement that we're not starting yet, which is obviously the worst kind of announcement of all. We're going to start in about 15 minutes. Please enjoy your lunch and conversations. We're looking forward to get started in about 15, 20 minutes. Thanks.
Hi, everybody. This time for real. Welcome. This is an amazing room full of amazing people to look out onto. Thank you all for being here. I'm Yuval Levin of the American Enterprise Institute, and I just want to say a few words of welcome to get us started, and just to thank you for joining us for these 2 days of thought and conversation in honor of Justice Antonin Scalia's legacy and memory. It's been almost exactly 10 years since Justice Scalia died, and in a lot of ways, his influence and legacy have only grown and flourished during that time. The direction that he helped to give to American jurisprudence, the conception that he advanced of the purpose of the judiciary and the role of the judge have become more dominant, more important, and also have, of course, remained and in some ways become more controversial over that time. His profound writings on judicial power, on the rule of law, on the character of America's democratic republic have continued to shape the thinking of lawyers and judges and citizens, and the questions that he raised are ones that we continue to grapple with in our time. And over the course of the next few days, we're in a sense going to do just that. We're going to grapple with those questions and consider the legacy and the continuing impact of Justice Scalia's thought and work. We're honored to have with us really an extraordinary all-star cast of judges and legal scholars, Supreme Court advocates, observers, and practitioners of the law to think through that legacy together. Just a few organizational notes as we get started. First of all, we at AEI are enormously grateful and privileged to be co-hosting this event with the Ethics and Public Policy Center. And we're particularly grateful to Ed Whalen of EPPC, who helped to bring this event together from its very earliest conception right through the final practical details. Ed has really done more than anybody anywhere, I think, to elevate and illuminate the legacy of Justice Scalia over these years. And in a lot of ways, this conference is also a testament to his own work. And thank you, Ed, for all of that. Second, my gratitude to my colleague at AEI, Adam White, who's done an enormous amount of the intellectual and practical work to get us here, and our gratitude to our colleagues Mikey Schwartz and Nicole Penn, and especially to AEI's events team, and particularly Elise Amsler, who has really done heroic work to get us to this place. These conversations matter a lot to us here. Celebrating Justice Scalia's legacy is a particular honor for us at AEI because Justice Scalia was one of our own. He was an AEI scholar in the years between his service in the Ford administration and his being named to the federal bench by Ronald Reagan. And those were really enormously productive and creative years for him. We're going to hear about those in a variety of ways in the course of these 2 days. And it's a source of great pride and great gratitude for all of us here to be able to celebrate his work today. And so finally, really, our thanks to all of you for joining us to honor Justice Scalia's memory and legacy and to think together about our country in this moment. With that, I'm going to turn things over to Ed Whalen of EPPC to say just a few words and introduce our first speaker. Thank you all very much for being here.
Thank you, Yuval. It's been such a joy to work with Yuval Levin and Adam White in organizing this symposium. On behalf of the Ethics and Public Policy Center, I'm very grateful to AEI for hosting this event and for the wonderful events team that helped put it together. And I want to thank the outstanding judges, scholars, and lawyers who are taking part in this symposium. We're grateful to have such a large in-person audience. We have a lot of folks watching online, and also grateful to C-SPAN that it is covering this symposium. It's my pleasure to introduce our first speaker, Paul Clement. Paul Clement was the Solicitor General of the United States from 2004 to 2008. He's widely regarded as the premier Supreme Court advocate in the country. He's argued 124 cases in the Supreme Court, and has, I think, 2 or 3 more to go in the coming months of this term. Among those arguments, 3 have delivered notable posthumous victories to Justice Scalia. There was his argument in a case called Rucho v. Common Cause in 2019 that held that claims of political gerrymandering are not justiciable, adopting the position that Justice Scalia had espoused in 2004. There's a case of Kennedy v. Bremerton in 2022 that certified the final demise of Lemon v. Kurtzman. Justice Scalia had famously complained back in 1993 that Lemon v. Kurtzman stalks our Establishment Clause jurisprudence like some ghoul in a late-night horror movie that repeatedly sits up in his grave and shuffles abroad after being repeatedly killed and buried. Now it's dead and buried. And Paul also argued the Bruin Second Amendment case, which reinvigorated Justice Scalia's landmark Second Amendment ruling in District of Columbia v. Heller. That said, I invite Paul to give our lunch remarks.
Thank you very much. Thank you very much, Ed, for that wonderful introduction. And I owe a real debt of gratitude to Ed because he was among the Scalia clerks who didn't stop the justice from giving me an offer. So in some respects, this is kind of all his fault. And I also want to give a special thank you to Jordan Fisher of Bloomberg News, because Jordan wrote an article about a month ago that did a lot of the hard work for me, because he pointed out in this article that Justice Scalia's name keeps coming up at oral argument in the Supreme Court over and over and over again. And it just is a real-world manifestation of the justice's continuing influence on the Supreme Court jurisprudence, and the like. And, Jordan did something that not every reporter does. He did some hard work, and he went through all of the argument transcripts since Justice Scalia passed. And what he found in those transcripts is some 300 references to Justice Scalia by name since the justice has passed. And that averages out to about 30 per term. This term, we're ahead of schedule. We already have 3 dozen references just in the first 3 sittings of the court alone. Now, to a Scalia clerk or a fan of the justice, these numbers might seem normal, even a little low, frankly. But the real story becomes clear when you compare these numbers with other justices who have recently passed. In the same period, there were 70 references to Chief Justice Rehnquist. And that's certainly a sizable number, but given that he was the Chief Justice, and given that the current Chief Justice clerked for Chief Justice Rehnquist, I might have suspected that number would be a little higher. And since her passing, there have been some 30 references total to Justice Ginsburg. So in addition to sort of the sheer number that show the justice's outsized importance, I think it's pretty fascinating to see who exactly is doing all this name dropping. Now, despite having been on the court for less than 8 of the 10 years since the justice passed, Justice Kavanaugh leads the pack with 25 references to Justice Scalia from the bench. Now, I'm also quite pleased to report that based on Jordan's research, and despite not being a justice on the court or even the so-called 10th justice anymore, I actually finished a close second. Which, like I said, I take as very much a point of pride. So I had 23 references to the justice in my oral arguments. But frankly, it gets more interesting from there. The people who finish 3, 4, and 5 on the list of the most Scalia references are Justices Sotomayor, Breyer, and Kagan, respectively. So to me, I really wanted to take this as a jumping off point to try to explain what is it that actually does explain the justice's continuing outsized influence. And I'm kind of embarrassed to say that after thinking about it a lot, I came up with something that I think the justice would hate, because I came up with a 5-factor test. So here are the 5 factors that I came up with. Now, first of all, I want to start with what I think is kind of the Occam's razor explanation, the simplest explanation of all, which is just the justice's jurisprudence is really what explains his continuing relevance. And I think there's two aspects in particular of his jurisprudence that help explain his enduring legacy. The first I'll start with is that the justice was always focused on methodology. He wasn't just focused on getting to a right result in a particular case, but he was really very focused on having the right methodology to get to the right result. And I think that really is a key to his enduring importance, because if you're a Supreme Court justice and you just decide a certain question, let's say of the bankruptcy code, and you resolve it, that decision's actually not that likely to have much enduring relevance, because you're the highest court in the land and you just resolved the issue, and now we can move on. But on the other hand, if you write an opinion that explains in detail the proper methodology for interpreting the bankruptcy code, or frankly, any legal text, then that decision has a chance to continue to play a role, continue to be invoked by advocates and other justices down the line. And of course, the justice was very much focused throughout his career on two great methodological battles. One he largely won, and another one that continues to be ongoing. As to the battle that he won on textualism in interpreting statutes and the limited use of legislative history, I do think even during his lifetime, he really saw that project go from sort of a quirky view from a junior justice to the established mode of interpreting statutes. I think during his lifetime, his thoughts on how to properly interpret the Constitution, principally textualism and original public meaning, I think sometimes were not always as much in ascendancy. There were some happy moments where I think he got great victories. Two that stand out to me is in the Confrontation Clause context. I've always thought his Crawford decision was just an essentially Scalia opinion, where he focused on what the text provided and not what the framers were on about in some abstract sense. And then, of course, the Heller decision that Ed alluded to, I think was one of his great triumphs of originalism, building on the work of Judge Silberman in the D.C. Circuit. And I think in that case, it was a little bit of a cheat, though, because thanks to the Miller decision, which kind of made the Second Amendment stillborn for about 70 years, the other justices had no choice but to be originalists. You couldn't sort of resort to a bunch of Warren Court opinions and ignore what actually happened at the framing. And I think in the years since the justices passed, some of those decisions that he issued about constitutional interpretation have gotten even more currency than during his lifetime. I would say, though, that although this focus on methodology is most evident in those two overarching debates about interpretation, you see it in other ways as well. And just to pick one example, which is class actions in Rule 23. Now, I don't think Justice Scalia is known as like the class action justice, but he actually, in a couple of opinions, I'm thinking of Walmart against Dukes and Comcast against Barron, really fundamentally reshaped the law in the country and in the lower courts on class actions. And I think it's noteworthy because Dukes against Walmart is a case where every justice thought that the particular class certification order in that case had to go. And so it would have been very easy to write an opinion that was very good for Walmart, but really didn't do much to reshape the law of Rule 23. And instead, the justice grabbed a hold of that opinion and wrote a decision about commonality and the requirements of commonality in class actions that really fundamentally reshaped the law. And his Comcast opinion was another one where he really transformed the law of Rule 23. So the second overall aspect, though, of his jurisprudence that I think helps explain his legacy is his well-known preference for rules rather than standards. A standard, if you adopt it, really doesn't, barely decides the case that you're involved in and really doesn't cry out for attribution. I suppose anybody who clerked during a certain number of years associates the undue burden test with Justice O'Connor, but still that's not much of a legacy. And I don't know that any justice wants to claim the totality of the circumstances. But when you come up with a clean rule that will decide the case and then provide guidance for future cases in the area, that's a rule that's worth invoking by justices and by counsel, and it's a rule worth claiming. And so there are certain principles of the law. I'll just pick one, the well-known elephants and mouse holes canon. But there is a principle of law that helps decide statutory interpretation questions that is distinctly Scalia-esque and sort of well worth something that you would have attributed to your name. All right, the second of my 5 factors, the treatise, the reading law book that the justice co-authored. I think that treatise has a really important part of this legacy and these references to the justice in Supreme Court arguments. And I think it really is worth thinking about how unusual it is for a justice to write a treatise about something, anything really, but especially like something like statutory interpretation. And so I think of Justice Scalia really as kind of the modern day Justice Story. I don't think he'd hate that comparison, but I can't really think of another justice who's written a treatise of such ongoing and enduring significance. And so a number of these references to Justice Scalia at oral argument are in fact references to the treatise, and that's particularly true of Justice Kavanaugh, who seems quite interested in what is lurking in the pages of that treatise. The hard data back this up. In the court's opinions, since the treatise's publication in 2012, there have been 86 references to the treatise in Supreme Court opinions. And 78 of those 86 have been after the justice's passing, the most recent as last month in Justice Barrett's opinion for the court in Burke against Choi. Now, there's 2 things I want to just briefly mention about this. First, the fact that there was a period where the treatise was published before the justice passed, and this is not a posthumously published work, is itself kind of impressive. Because if you think about it, if you're a justice and you're writing a treatise on how to interpret statutes, you are essentially inviting both advocates, but even to a greater extent, your colleagues, to hold your feet to the fire, to say, look at what you said on page 287. And he wasn't worried about that. I mean, he was laying out his best view about how to read the law, and to the extent somebody was going to hold him accountable, I think the justice would have preferred that. But the fact that it continues to have growing salience in the years since his passing is in many respects more impressive. And as with the references to him at oral argument, I think the number of references to the treatise become more impressive when you have some comparison points. And so to go to the, to sort of the granddaddy of all Supreme Court justice treatises, stories, commentaries on the Constitution, in the same period that there were 78 references to Justice Scalia's reading law, there were 40 references to Justice Story's commentaries on the Constitution. So when you're beating Justice Story by a 2-to-1 margin, I think that's pretty impressive. But here's the one I think is in some respects even more telling. So in the same period, the same 10-year period, there were exactly 3 references to Professor Lawrence Tribe's treatise, American Constitutional Law. The 3 references may actually surprise you. Those 3 references were by a grand total of 2 justices, twice in dissent and once in a majority opinion. The 2 justices are Justices Thomas and Gorsuch, and that's it. 3 references over a 10-year period. Now, I don't mean any disrespect to Professor Tribe. This is an enormously influential treatise, and to help demonstrate that, there have been a total of 70 cites to the treatise since its original publication in 1978. And I don't think there's any, I haven't run the numbers on everything, but I quite doubt there is a modern constitutional law treatise that's been cited anywhere near that number of times. And I can also profess that Justice Scalia himself had a hard copy of the treatise in chambers. So it is quite influential. But I think it's fair to say from the numbers that the influence is waning. And if you think about a 10-year period where there are 3 references to that work and 78 references to Justice Scalia's reading law, I think that tells you about which interpretive methodology is in ascendancy in the current court. All right, factor number 3, and in some respects the most fun to talk about, is the writing. I mean, Justice Scalia's gifts as a writer are absolutely legendary, and they certainly make him more quotable from the bench and from the podium than almost any other justice you can imagine. I'll talk about that in somewhat concrete terms in a minute, but I want to start with one of the fondest memories I have of my year clerking for the justice. And I actually got a little bit of a break from the kind of ordinary work of a law clerk on the cases, and the justice asked me to help him out on a speech/article that he was working on about dissenting opinions. And since the year I was clerking for the justice, that was most of what he was writing. This seemed like a really fun project, and the justice was very, very interested in it. And the article is out there. I highly recommend taking a look at it. But 2 things about the work with the justice and the article itself stand out to me. The first is in this article on dissenting opinions, he pointed out that essentially people have to read majority opinions, at least lawyers do, because they're the law and they're authoritative. And so even if they're written poorly, like, you got to read them. That's your job. But nobody has to really read a dissent, and there's no really point in writing a dissent, he pointed out, unless it's memorable and well-written. And so I think in some respects, the fact that some of the justice's best lines, not all of them, but some of the justice's best lines came from his dissenting opinions is no accident. The justice himself understood that there's no point writing one of those unless it's going to be interesting and memorable. But the other part, I will say, that underscores, I think, the importance of a justice's writing ability as part of their enduring legacy is what happened when it got down to sort of editing the article. And, the justice started off with this kind of like almost quaint notion that he didn't want to pick any favorites in this article, so he's going to select a couple of really notable dissents throughout the court's histories, but he didn't want to pick favorites. So he started out with the intent of having just one quotable dissenting opinion per justice. But we got working on the article, and he kept on going back to Justice Robert Jackson. And in the final analysis, the justice said, the heck with it. We're just going to finish with like 4 or 5 Jackson quotes, and that's how we're going to end the article. And obviously, Justice Jackson was a uniquely gifted writer. He remains very quotable many, many years after his service on the court. But I'd put Justice Scalia up against anyone, including Justice Jackson, and I think some of these enduring lines will be cited long after the rest of us are gone. So, what does this lead? I'll just finish on this point about the writing with a couple of quick observations. One is that I think this means that the original article that singled out identified all of these references to Justice Scalia at oral argument is actually massively undercounting the number of references to the Scalia article. Because I checked on the methodology here. Justice Scalia would be proud. Methodology is important. And the only references that got counted were express references to Justice Scalia by name or other justices by name. So if a lawyer, and no lawyer would ever do this, right? But if a lawyer actually said in a Supreme Court argument, this wolf comes as a wolf, but didn't give any attribution to, as Justice Scalia would say, this wolf comes as a wolf, that doesn't count. So I think the justices' numbers are, I can tell from my own experience, radically understated. And these memorable lines, I mean, they are not just great lines in the opinion. Sometimes you can write something that works in writing, but really doesn't translate to oral advocacy or questioning by justices. But the genius of Justice Scalia was to capture a complicated concept and an important concept in just a few words. Elephants in mouth holes. That gets bandied about in the Supreme Court all of the time. This wolf comes as a wolf. Like, what better way to sort of paint something as an overt violation of the separation of powers, or really anything else? You can use that phrase all over the place. And then, so it really does capture his ability. And it is worth noting, these lines come from all different Scalia writings. So elephants and mouse holes, a majority opinion. Wolf comes as a wolf. Of course, the famous Morrison v. Olson dissent, maybe not a dissent for much longer. But even his non-judicial writing figures in the court's opinions and in advocacy, and even from ones from before he came on the court. And so it is impossible for a Supreme Court justice in this day and age to write a standing opinion without quoting Justice Scalia's Suffolk Law Review article, where he sums up the entirety of Article 3 standing doctrine into the phrase, "What's it to you?" Now, what a beautifully Scalia-esque phrase. Pithy, it captures the whole thing. If you know the justice, you can almost picture the accompanying gesture. What's it to you? What's it to you? Why are you here? Why are you wasting my time? And literally, case after case in the modern era invokes that article as part of its analysis. So 2 other factors. We're almost done with the 5 factors. The 4th is the justices on the current court. And if you look at the justices, these are justices who either sat with Justice Scalia or have some direct tie to sort of the justice and his legacy. I mean, you have one justice, Justice Gorsuch, who filled the justice's seat, and apparently that seat came with an inherent disdain for legislative history. Just it conveyed. A second of the justices is the one who leads the pack in invoking his name at oral argument, Justice Kavanaugh. Another one clerked for him. And as I said, with the exception of Justice Jackson, all the others served with him and kind of understand both his inimitable personality, but also the influence that he's had on their own thinking about the law. And the 5th and the final of these 5-factor tests is the advocates. I guess I would sum it up pretty simply by saying for an old law professor, and there are plenty of panels here that are stacked with Scalia clerks who went on to be distinguished law professors, but for an old law professor, Justice Scalia produced an awful lot of Supreme Court advocates and other practicing advocates. And the numbers, again, bear this out. I mean, first of all, obviously a lot of kismet in this, but 3 of the justices' law clerks, including the current holder of the office, went on to become confirmed solicitors general. And 3 might not seem like a big number, but nobody else has got more than 1 in terms of a law clerk who became a confirmed solicitor general. And so there's been this kind of almost, I would say, fair or unfair, I'd say great. There's been this dominance of Scalia law clerks in the SG's office from my own time to the current time. So that's, I think, part of it. But it's not, I mean, becoming Solicitor General is a little like having lightning strikes. So the numbers really go on much beyond the sort of the SG's position itself. And so if you look at just this term, there have been 20 appearances at oral argument by former Scalia clerks at the court this term. The court doesn't hear that many cases these days, so 20 cases is pretty impressive. Those 20 appearances were spread across 11 different advocates. And I can attest that I had 3 arguments this term alone where my friend on the other side of the podium was not just my friend, but my fellow Scalia clerk, 3 times this term already. So it really is, I think, no accident. The justices that served with the justices, law clerks who are arguing in front of the justice. I mean, I think I can speak for every law clerk in that if you spend a year with the justice, you never think about the law the same way, and you never think about it without stealing some lines from the justice. All right, so let me just finish up with a little bit of a coda. In many respects, what this article and this 5-factor test show is that the justice is very much still with us, still influencing the Supreme Court and the trajectory of its cases. But there's one place in which I think, at least personally, he's really, really missed, and that is his own presence at oral argument. After the justice passed, there was this kind of poignant display in the Supreme Court where his chair behind the dais was shrouded in black. And that was incredibly moving to me. I think it was moving to all the law clerks. But, in some respects, I feel like there's still a little bit of that black cloud that the justice is not on the court. He had such an incredible influence on oral argument. He was such a pleasure to argue in front of. And I think in many ways, as much as the justice has impacted the work of the Supreme Court, the substantive doctrine that emerges from the Supreme Court, he's had, again, that methodological influence. He's changed the way that Supreme Court oral arguments take place. In the 1970s and the early 1980s, all you got to do is go to oyas.org to confirm this. It was very common for Supreme Court advocates to be asked only a handful of questions during oral argument. That changed when Justice Scalia joined the court. Indeed, it changed on day one. The justices had obviously been told that there was something of a tradition that a new junior justice is supposed to kind of hang back and allow more senior colleagues to lead off the questioning. And while I'm sure it took enormous self-discipline on the justice's part, he waited a good 15 minutes into the argument before asking his first question. He then asked the next 10, and a total of 28 in his first argument as a sitting justice. The other justices eventually followed suit, lest the new guy have all the fun. And things have really never been the same in the Supreme Court in the United States for either the justices or for the advocates. Argument before the Supreme Court is now the art of answering questions, and moot courts are no longer optional. I don't think it's an accident that the Solicitor General's office formalized its moot court process, and the Georgetown Supreme Court moot court program was founded after Justice Scalia joined the court. Before that point, you could probably get around with a round table, just kick the ideas around, and we'll go talk about it in front of the justices. But after Justice Scalia joined the court, you could not leave home without a moot court. At the same time that he made oral argument a lively affair, he made clear that it need not be dour. Justice Scalia injected humor into his colloquies with counsel and asked many questions with a twinkle in his eye. He was routinely ranked the court's funniest justice, as judged by the court reporter's need to note laughter in the transcript. And it was fun to argue in front of him in another way. You could say almost anything in response to one of his questions, and he would not take offense. Most of my favorite exchanges with the justice, looking back on it, were exchanges with Justice Scalia for exactly that reason. If he asked you some snide question about legislative history and you'd thought about it and had a good response, you could say something. He once asked me, well, how many legislators were in the chambers when that particular colloquy took place? And I looked at him and I said, the same number that were in there when the other piece of that colloquy that the court put in its majority opinion last term. And that's a pretty smart alecky answer, but he loved it. He loved it. I think the justice asked lots of hard questions, but he affirmatively wanted the advocate to push back. So to paraphrase the justice, he never expected the advocate to follow the Marquis of Queensberry's rule while he fought freestyle. He wanted it to be a fair fight. Let me close with my favorite exchange with Justice Scalia at oral argument. This case involved whether the court should extend an implied cause of action, an issue that's still very much with the court. The justice was not a fan of implied causes of action, or anything implied for that matter, and he criticized the court's practice in what he called the bad old days of inferring causes of action that appeared nowhere in the enacted text. There was some confusion at oral argument about whether a particular court precedent was a product of, quote, those bad old days. And Justice Scalia asked me when I thought the bad old days ended. My answer, then as now, was, of course, quote, the bad old days ended when you got on the court, Mr. Justice Scalia. I thought that was a great answer, and so did he. But the even better news is that the good old days did not end with the justice's passing. They are here to stay thanks to his enduring jurisprudence, his treatise, his inimitable writing, and the justices and advocates that continue to debate his enormous legacy. Thank you.
Thank Thank you so much, Paul, for getting us started in just the right way. We're going to take just a brief break. Enjoy saying hello to some friends, finish your lunch, find the bathroom. We can help with that. And we'll get started on our next panel in about 15 minutes.
You all set?
Yeah.
Okay. I was just going to introduce
That's great.
you.
No, that's
Is that
great.
okay? All right. Oh, good. All right. If people take their seats, we'll get started in just a moment. Well, Paul Clement is obviously a pretty tough act to follow, but I have good news. We are starting with the first panel of the next 2 days and a great subject to begin with. It's titled Executive Power and the Separation of Powers. We have 3 excellent guests you'll be hearing from: Stephen Engel, our colleague John Yoo, and Solicitor General John Sauer. They'll be introduced by their moderator, and I have the honor of introducing the moderator. Our panel is being moderated by Judge Daniel Bress. He was appointed to the U.S. Court of Appeals for the Ninth Circuit in 2019. He previously practiced law at Kirkland & Ellis and at Munger, Tolles & Olson. After graduating from the University of Virginia School of Law, he clerked for Judge J. Harvey Wilkinson on the Fourth Circuit, and then he clerked for Justice Scalia on the 2006-2007 term. So thank you, Judge, for joining us today, and the floor is yours.
Okay, well, thank you. It's a Washington. Thank you. It's a Washington tradition for somebody to introduce the introducer. So I want to say, first of all, just a couple words of gratitude. First to Adam, thank you for the kind introduction. Thank you to AEI for doing this, and to the whole staff, Adam, Yuval, everyone who has put this together. It's just a wonderful moment to be able to celebrate the justice at this point, 10 years after his passing, and at this moment. So I want to thank everyone who did this. I want to also thank Ed Whalen, who's been instrumental in putting all of this together. And I will say, as a Scalia clerk, I think Ed, more than any other Scalia clerk, has done so much to further the justice's legacy and honor his memory with his writings and his contributions. And I have the privilege of getting to speak with young kids who come to the court to see our argument or meet with judges, and when I tell them I clerk for Justice Scalia, their eyes, open a little wider because they know who that is. They've heard that name, and thanks to Ed's great work and contributions, generations of people and young people will be able to learn more about the justice and his life and his contributions. So, Ed, on behalf of all of us, thank you. I think for all of us, there's certain moments in our lives where we remember where we were, and I certainly remember where I was when I learned that the justice had passed. And clerking for the justice was the honor of a lifetime, but for many of us in this room, and certainly for me, the justice would have been a profound influence even if I had never met him in person, even if I had never worked for him, because of the things he wrote and because of the things he said and the principles that he stood for that were so important and that resonated so much with me as a young lawyer, as I was beginning to think about some of these important issues. The topic we're going to be discussing is executive power and the separation of powers. It's our first panel, and that may be not coincidental, because the justice was a towering figure in this area of law. Perhaps more than any other justice in history, he brought renewed focus and reinvigorated the idea of a structural constitution, the idea of the separation of powers, and the importance of the framers' design for the organization and architecture of our government in a way that would promote individual freedoms and individual liberties. Many of you have probably seen the justice's comments. He gave these remarks at many different times where he would read beautiful quotes from a constitution that protected all these different rights and all these important rights. And then he would tell the audience, those are actually quotes from the Constitution of the USSR in 1977. And the point he was trying to make was that the Bill of Rights and the rights that were granted under the Constitution are essential, but let's not forget the important structural protections that the Constitution put in place through the framers' ingenious design. And the justice was at the forefront of promoting a greater understanding of these basic concepts that had been lost to many decades of history, especially at the Supreme Court. And he was a distinct voice on this issue. And he, of course, came to the court with a tremendous background and deep insights in this already, not only as an academic, but from his time at OLC, including later as a time on a judge on the DC Circuit. And then from the moment he got to the Supreme Court, almost immediately penning the classic dissent in Morrison v. Olson and making his mark as the justice who I think will forever be known as the one who brought renewed focus and attention to the structural Constitution. So with that, I want to introduce this great panel that we have here. I'm going to introduce each of them, and I'm going to give you a fun fact about each of them as well. So in the middle, we have Steve Engel. Steve's a partner at Deckard and the chair of its appellate and regulatory litigation group. That's not the fun fact. I'm getting to that. Before rejoining Deckard, Steve served actually in the Justice's old job as the Assistant Attorney General for the Department of Justice's Office of Legal Counsel. And Steve was a law clerk to Justice Kennedy. And the fun fact is that Steve is married into the Scalia clerkship family through his wife, Susan, who was a law clerk to Justice Scalia. John Sauer, to my right, is the 49th Solicitor General of the United States. John was nominated by President Trump, confirmed to that position by the Senate in April 2025. He served as the Solicitor General of Missouri from 2017 to 2023, and as an Assistant United States Attorney for the Eastern District of Missouri from 2008 to 2013. And when John was not in government service, he founded a law firm, the James Otis Law Group, and engaged in criminal and civil litigation and appeals. And John served as a law clerk to Justice Scalia during the October term 2005. He's a Rhodes Scholar, graduate of Harvard Law School. And John's fun fact is that we overlapped for 2 weeks together as law clerks to Justice Scalia. Those were the two most important weeks of our careers. So, and then on the far end, John Yu. John, I'm going to begin with John's fun fact, which is that John is my Bay Area lunch friend, and we get to see each other.
It'll be fun when you pay the bill.
Easy, John. We split every bill. John, in addition to my job as a Ninth Circuit judge, John and I find ourselves on a lot of panels. So my other main responsibility is introducing John at different events like this. So John is the Emanuel Heller Professor of Law at the University of California, Berkeley. He's a non-resident senior fellow here at AEI. He's a distinguished visiting professor at the University of Texas at Austin School of Civic Leadership. And John is also the author of numerous books and articles on executive power, international law, constitutional law. He's served in all three branches of government, including in the OLC, and as a law clerk to Justice Thomas. So please join me in welcoming this distinguished panel. So I'm going to begin and continue with various open-ended questions, and we'll see where this discussion goes. And the first question I have for this panel is just to give us your kind of introductory thoughts on what were the Justice's key insights and contributions in the areas of separation of powers and executive power? John, fire away.
That's quite an open-ended question, and a very rich topic that I'm sure someone could talk or do dissertations on. Maybe I can offer two reflections. I think that sort of based on my recently reading some of the court's important for my day job, the court's important opinions on separation of powers. And these, I think, go to kind of the influence of Justice Scalia earlier in his career. I think you see a sea change in the court's opinions between the 1970s, where you have a very functionalist approach to separation of powers in cases like Nixon against Administrator and so forth. And then in the 80s, there's some marquee opinions, INS against Chadha in 1983. You have Boucher against Sinar in 1986. And I think that people are starting to recognize and write about the influence that then Judge Scalia and actually Professor Scalia had on those opinions. So I was recently reading Boucher against Sinar, and I was like, I forgot that this opinion is just quoting this three-judge per curiam opinion from the D.C. Circuit again and again and again. Well, that, of course, then Judge Scalia was on that panel, and it was considered, I guess one of the biographers says, it's an open secret that he wrote the whole per curiam. The per curiam it contains like many of the nuggets of wisdom that you then find coming out when he's a justice, and he puts in the Morrison dissent and the Stretta dissent and things of that nature. Clearly, there's a sea change between the standard that they adopt about how are you going to assess separation of powers and encroachments in Article 2, for example, between Nixon versus GSA and that decision. And there's a line there, I think, that goes through INS against Chadha. And in Chadha, Justice Scalia, Chadha, I think, was argued, and he was confirmed to the D.C. Circuit while it was under submission to the court. But as a law professor, he submitted an amicus brief on behalf of the American Bar Association in that case. In the first section of the amicus brief, he argues that, this is an encroachment on Article 2 powers. But the second section of the amicus brief, he argues the ground the court actually decided, and I think he was the only one arguing that other than the Solicitor General, which is that this formalist insight into the nature of legislative power. It's purely an Article 1 holding in Chadha, but it adopts this formalist view of Article 1 that I think was really influential. So Justice Scalia may have an influence in the outcome of INS against Chadha, and I think clearly had a powerful influence on the formalist decision in Boucher against Sinar. So I think there's an untold story of, maybe it's being told now, I think, but a told story about his influence on what really is, I think, the critical turning point in the court's jurisprudence on that, which happens between the 1970s and the early 1980s when the then Berger court starts adopting these formalist holdings. And that ties to my second observation on this, which is formalism. The Justice Scalia of that, Judge Scalia, Professor Scalia, and then early Justice Scalia heavily emphasized formalism. Obviously, when you get to his doctrines of textualism and originalism, they're so influential, there's a lot of question of what's authoritative, what's actually binding, what is the law? Linked to that in his mind is the question of what actually is this concept. He puts the very, very last point, substantive point I think he makes in the Morrison dissent is, if we just have some mushy standard that's not really going to bind the reviewing court's discretion, give them the latitude and freedom to pick any rule that they want, this isn't a government of laws at all, as the way he puts it. And so I think that switch, the sea change you see that he very likely did influence in the 80s before you get to Morrison and subsequent cases, is a switch from functionalism to formalism in the way the court viewed the separation of powers. And I think we're still seeing, the implications of that sea change unfold in the current era.
Steve. Great. Well, I did not know that there was a time when the American Bar Association was represented by Justice Scalia and argued for the structural separation of powers. So that alone is worth the price of admission. Just building on what John had said, Justice Scalia started this perhaps before he was on the court, but of course, he dissented alone in Morrison, and he dissented alone in Mistretta. And in both cases, you had lopsided majorities of the court continuing to push the functionalist view of separation of powers, that the Sentencing Commission may or may not be within the judicial branch. It's maybe somewhere else, in sort of logic reminiscent of Humphrey's executor and the like. In Morrison versus Olson, that executive power can be given to an independent counsel so long as it's not too much executive power, and so long as the president, through the attorney general, can sort of, maybe sort of influence, the course of events there. And so, this was a justice in dissent. He wasn't alone, because of course he had Larry Silberman on the DC Circuit, which was the decision that the Supreme Court reversed in Morrison versus Olson, but he was alone on the Supreme Court. And you go from that, and you go over the decades and what was built by Justice Scalia to where we are now, where taking the structural separation of powers seriously, taking executive power seriously, appears to be the dominant theme on the court. And we've over the last 20 years, we've gone from Free Enterprise Fund and Seal of Law, Lucia and Jarkissi, and all of these things are going on. And these are ideas and thoughts that Justice Scalia had in his earliest years in the court, even on the DC Circuit. But this is now the law of the land. And this project, which started with these lonely dissents, has succeeded in ways that I don't know that any of us could have anticipated. And a lot of it is through the force of the justice's reasoning, through his calling out to sort of originalism, a renewed interest in the framers and the Constitution and the Federalist Papers, another thing he talked about whenever he was out there. And some of it is also just fortuity of the way the court has developed over the years, but it has been clearly a vindication. And then maybe just saying a word specifically on executive power, what Justice Scalia wrote about was a focus on the unity and therefore the accountability of the president. The executive branch is one, and the president is accountable for all the actions of everyone within the executive branch. And this is something that Hamilton wrote about in the Federalist Papers as well. But again, this is now the law of the land. In a few months may well be, in fact, the law of the land if, as expected, Humphrey's executor is overturned. But this is something that the justice wrote about not only in dissent in Morrison versus Olson, but this was threaded through a lot of decisions we don't think about as executive power decisions. This is one of the reasons in Prince versus the United States that Justice Scalia, writing for the court, said that Congress cannot commandeer state officials to implement federal programs because this would destroy the unity of the executive branch. This is also one of the reasons, not the only reason, but one of the reasons that the justice was such a hawk on standing doctrine. Because again, in Lujan, what he's talking about is that if Congress can allow private attorneys general to take care that the laws are faithfully executed under judicial supervision, this too would fracture the unity of the executive branch and the accountability that the president must have for enforcing federal law. And so, this is, like many of us, I remember where I was, 10 years ago when my wife and I heard the news, of Justice Scalia's passing. But on the law, the last 10 years have surely, brought us closer to kind of what he was talking about all the time.
Judge, thanks for a kind introduction. It's great to be on a panel with real lawyers. I'm just a law professor, so I pretend to be one. I have had the best of all worlds because I didn't have to clerk for Justice Scalia, so I didn't have to do what he told me to do. But I got to drive him every week for my clerkship, twice a week to go play squash and tennis. And so I spent hours in the car talking to him. And this was 1994. And so a lot of the great decisions had not come out yet, but Morrison had come out. And I used to talk to him for hours about Morrison versus Olson. Like, why did you think this? I also clerked for Judge Silberman, so I said, why didn't you just reprint Judge Silberman's opinion as your dissent? You might notice in his opinion, he has a funny line where he says, I could go into it more, but just read Judge Silberman's dissent, opinion below, which Judge Silberman thought was the greatest sentence in Supreme Court history. And then I was clerking for Justice Thomas, so like John F. Kennedy when he received an honorary degree from Yale, where he said he had the best of both worlds, a Yale degree and a Harvard education. Mm-hmm. I have the best of both worlds, a Thomas clerkship and a Scalia friendship. Mm-hmm. Because the thing I loved about him, the thing I loved about Judge Silberman, the thing I loved about Justice Thomas is they would treat the clerks like equals, right? They did not think I'm the justice and you're the clerk. They loved to argue all the time with you one-on-one and wanted you to persuade them, not just because hierarchical, they were the justice and you worked for them, that they were going to be right. And that's one thing maybe you can see in Justice Scalia's personal appearances on video or some of his writings, just loved debate and argument. It was such a privilege of mine when I clerked to be able to, I never let him win, make it close enough so he'd keep trying, but to play squash with him twice a week for a whole year and talk to him about all these issues. So the two things I just wanted to add in addition to these great comments, that I would talk to him about was, one, there are a lot of people at the time that I was in the academy writing psychological studies about Justice Scalia and trying to figure out, why is he so formalist? Right? Why does he love the presidency so much? They just like, this can't be legal reasoning. It must be something with his upbringing. And so I would ask him, Justice, is there something about the way you were raised that made you love the presidency? And he loved, so he had a hate-hate relationship with the professorate because he loved to hear what they were saying about him. He loved, when I tell him, there's this law review article published in Yale about your youth and how it connects to your opinions. He thought this was the funniest thing ever. And I said, oh, please read me some of it. I said, I'm driving. I don't think I should read to you while I'm driving. But Sicilian drivers, this doesn't appear to be a problem. Sometimes I had to follow them, and it appeared Sicilians also descend driving habits along with their genealogy when they moved to the United States, because if any of you know about his driving, it was a terror to behold. But then the other thing I asked him about, and this is a more serious point, is as a judge, think about the times he's writing these opinions. You don't have the great burst of legal research and scholarship on, say, the removal question. He was really writing these things for the first time. And now we've had hundreds of articles on the removal question that he raised in Morrison versus Olson. And I think that's been part of what we're going to see, the development that we're going to see, I think, this year. I agree with both of you that the court will overturn Humphrey's executor, may even subject the Federal Reserve Bank to the president's control. But, sorry.
I made no comment on that.
I'm trying to make news here, John. I'm trying to get.
To be clear, John accepts for purposes of argument that the Federal Reserve is independent of the president. In this case, it's not about presidential control of the Federal Reserve.
You were such a killjoy. That's why you didn't clerk for Scalia or Thomas. But the thing I wanted to ask him about, I spent a lot of time talking to him about, was how much of a positivist are you? Are you really so Holmesian that if our Constitution did not have a separation of powers in it, do you think that it's the right thing to have in a Constitution, that you would have tried to move the case law, to try to move doctrine in favor of the kind of separation of powers we have, even if our Constitution was vague or ambiguous about it? Or did he really think that the Constitution as written made that choice, that it made the choice of a unitary executive and a formalist separation of powers? Because that's what I always wondered about him. He was always, I think in his public speeches, always talking about being a positivist, that he seemed to share Holmes's belief, right, that if the American people voted to go to hell, he would help them go, right? That was the written law. But I always wondered what he really believed when he wasn't being the positive judge. And he was a really slippery bastard. I could not get an answer out of him. I really wanted to know what was his belief, putting aside the written Constitution. And so that's the thing I've always wondered, and I thought that would be something interesting to discuss, is, Justice Scalia is a famous positivist, but did he believe there were any sort of natural law principles behind the Constitution that helped give force? And so I never talked to him about it, but I thought you do see it in the Second Amendment case. I think, which probably to most Americans is his most famous opinion, is the Second Amendment case, where he says that the right to have a firearm is an implementation of the right to self-defense. But the right to self-defense isn't in the Constitution. He says it's just part of the social compact. I think there you see the glimmering that maybe Justice Scalia did believe in natural law and natural rights, although most of his statements were about being a positivist lawyer, and the separation of powers was just our founders' choice. But thank God they made it, because I think he thought it was also, as a matter of consequences, the most effective form of government for the country.
Well, so let me pick up on where John just left us, which is what was influencing the justice most in developing these early ideas and then executing upon them during his time at the court. And John, obviously, we've heard a lot about formalism as a concept, as a method. You raised the issue of natural law. I'll throw into that historical understandings. We can include in that perhaps his own experiences working in government and having seen government in action. And perhaps we could add to that the idea that this structure would actually be conducive to promoting individual liberty. So are any of these strands things that you think were motivating the justice? When you read his writings, can you see this in them? And John, maybe we'll start with you.
I would say yes, all of the above. The justice was a visionary genius, and I think almost everyone will concede that. And so I think he could see all these things. And you say they aren't really separate strains in his mind, I imagine. There's a strain of formalism, there's a strain of history, there's a sort of structural insight, and then I alluded to earlier his sense of what's actually an authoritative source of meaning, what's authoritative to an interpreting court. I think he saw those as all kind of working together, and that's why we talk about his influence on textualism, influence on originalism, influence on this, the structure of the Constitution and separation of powers. It's really a unified theory, and that's why it's so compelling and has this lasting force that a decade later we're talking about how his influence is on the ascendancy, as Mr. Clement said before us. So I think those is all kind of running together. He sees them, and I think it is telling. I remember reading the early writings. Just an anecdote. I remember I became a sort of convert, so to speak, in the second or third week of law school. My civil procedure professor, Elena Kagan, assigned us to read, Burnham against Superior Court, which is a question of whether or not you can acquire personal jurisdiction by effecting service of process within the borders of the state, right? And so up until then, the due process precedents had adopted this kind of squishy multi-factor test of whether or not it's okay. And Justice Scalia wrote a plurality opinion. He couldn't get 5 votes for it. A plurality opinion saying, well, look, our history is historically, this was the touchstone of establishing personal jurisdiction. You serve them when they're in the state. So, you land at the airport, the process, you get off the airplane to, get a cup of coffee, the process server serves you, you get back on the plane and fly away. That transitory contact, as long as it's personal service in the service of the state, is sufficient to establish. He writes, this is our history, this is it. And at the same time, he's tapping into this question of history and tradition. That was a huge strain of his thinking, while adopting a clearly formalist view where there's a clear answer that a judge can get to and apply without applying a bunch of subjective factors, that has this element of the law of, the rule of law is the law of rules to it. So, and when I read that, I was like, this is the right way to think about the law. Nothing I'd read in the 2.5 weeks prior to that kind of like made any sense in light of that. And from then on, I was always going straight to the Scalia opinion, when anytime you're reading case law. And I think a lot of law students have a similar experience. So I think it'd be artificial to separate them. I've been focusing recently on the formalism that he emphasizes in those early writings. They're not that early compared to his time at OLC, but in the 80s and so forth. But I do think that in his mind, it's a coherent, unified theory, and that's why it's so compelling.
Yeah, no, I agree that he is the strength of his influence comes from the strength of his ideas, and his ideas. He worked closely with Bob Bork when Bob Bork was the Solicitor General during the Nixon and Ford administrations, and obviously Bob Bork was writing these things, even 10 years down, earlier than Justice Scalia was, and so. The notion of democratic legitimacy and what does it mean to be a judge, what does it mean to wield the judicial power and to be applying legal principles is something that is very appealing, particularly when written as evocatively and persuasively as Justice Scalia could. And I think it's that has translated. I will say just a note about his time at OLC. During the Ford administration, he was actually nominated by President Nixon. But President Nixon didn't see through his confirmation process. President Nixon resigned shortly before Justice Scalia was confirmed at OLC. And this was the high water mark of the legislative assault on the executive branch. Empowered by Watergate and everything that came with it, you had lopsided majorities in Congress that were overruling presidential vetoes in passing a series of statutes that for maybe one time, or it certainly has not happened since. Who knows if it will ever happen in our country? But where Congress was able to take back power or take power from the executive, and so this was a time in which he was often testifying in front of Congress, often testifying in favor of executive prerogatives against unwise expansions of the FOIA statute, including to sort of seek to have judges evaluating whether national security information should be released at the time. And I think I don't want to over psychoanalyze it or suggest, that, he was merely reacting to a particular experience, but this was a time at which he was standing up for the executive branch. And certainly I think it's consistent with the views that he articulated when he was a judge and when he was a justice as well.
Yeah, just as a compliment, in addition to what's been said, I think one way to think of Justice Scalia is as a veteran of the wars of Watergate. And I think compared to Judge Silberman, Justice Scalia, and Robert Bork, they're all veterans of that. And I think they all reacted similarly. In fact, where did they go after they left office? Here at AEI. They spent several years together here, I think, trying to develop a more proactive agenda for the courts. Because I think they all left their experience thinking that the presidency, but not just the presidency, but the idea of a restrained judiciary was under assault, if not had suffered a permanent defeat. And so I think part of that may why Justice Scalia had not just, I think, a profound desire to restore the presidency and reverse the Watergate quote unquote reforms, which I think are actually my way of understanding I'm not putting the SG on the spot again, but that's my way of understanding the Trump administration so far and its various actions in lots of different areas is they're just sort of undoing what the harm to the presidency that had been undertaken during Watergate. And it's just taken 50 years for that to happen. But also I think Justice Scalia, he went to law school in the years after Brown. And Harvard Law School at that time was this place that was seeking to try to reconcile Brown and this liberated Warren Court with their more traditional notions of the judiciary and its place. And so whenever I worked with any of the three, I always noticed every time they thought about any question, their first question was, what is the proper judicial role? Before they moved on to the substance of the question. And I think that comes from being a law student at Harvard Law School in the years after Brown, there's this thing called the Hart and Sachs Legal Process School that tries to figure out a way to tame judicial review in a way and make it fit into a traditional separation of powers and federalism framework when all kinds of theories are being unleashed by Brown, most of them being launched by Yale Law School professors, unfortunately, I would say, because I had to hear about them for 30 years after that. But I would say this is just Justice Scalia's way to understand, I think, the way he thought is he looked at the consequences of Watergate, looked at the consequences of Brown, thought they were quite harmful to our governing system, and tried slowly, case by case, to try to put the bricks back into the system as it had been before. So when I read his opinions, I don't think he's making any claim of radicalism. He's sort of, I think in the separation of powers, claiming he's restoring things to the way they had been and the way the system had worked for a long time until these more radical reforms of the Watergate period.
One thing we haven't discussed is the role of the Federalist Papers. And the Justice is writing many opinions in these areas, relying heavily on the Federalist Papers. And he would often give speeches where he would, tell law students to make sure you read the Federalist Papers and not just the key ones, but to actually read them from beginning to end. And I don't know if anyone has seen his testimony in front of Congress where he makes the same point, and Justice Breyer is sitting right next to him listening and just kind of enjoying this whole moment. And but that was something he told the Senate Judiciary Committee when he was testifying on some matter or another. So what role did the Federalist Papers play in the analysis of any? Some people have made the claim, well, it was just kind of window dressing. Other people have said, no, it's actually integral to the analysis and to the setup. Any thoughts on that topic?
I actually think the more important paper for him was the Pacificist Papers. Because Hamilton, in the Federalist Papers, he just but he sketches out the executive. But I think it's Hamilton in the Pacificist Papers that produces the theory that is Justice Scalia's theory, the idea that Article 2 says the executive power is vested in the president, right? And that's Scalia's famous words. It doesn't say some of the executive power, it says all of the executive power. That is almost word for word what Hamilton says in the Pacificist Papers to defend the president's power to conduct diplomatic relations. And I think it's that theory, which is not really as strong in Federalist numbers 70 and 70 through 75, where the executive power is discussed, but it's implied. And then in the Pacificist Papers, that's where it really comes out. I did this study once. I don't know why. I was curious how often the Federalist Papers were cited by the Supreme Court. And so the year after Justice Scalia joined the court, the citation of Federalist Papers and Supreme Court opinions went up 400%. So I don't know, cause, effect. It's so hard to figure these things out. But around 1987 to 1988, if you look at Warren Court opinions, they never cite the Federalist Papers. Honestly, they don't. They just, it's just this new thing. Look at this new thing we have. Justice Scalia brought this weird book into the conference, is reading from it, the Federalist Papers. But after he joins the court, they shoot way up 400%. The citation rate. So I think that's because of his interest in it. And he was, these dissents we're talking about, forcing this sort of functional majority that likes to say, the separation of powers is violated when we feel it's unbalanced, right? That's how they approached it back then. And Justice Scalia is almost like in his dissents reading them selections from the Federalist Papers, from Hamilton's writings, and forcing them to respond. They don't have answers. They start reading the Federalist Papers too, which means that Rossiter and Corwin are making a lot of money in their states for their edited Federalist Papers because they're now sold and read all the time. And I also bet that they weren't widely read in Poli-Sci 101 before 1987 and 1988. And now it's required reading again. I think that's a lot to do with him.
Yeah. And again, just the fact that that this being cited in the U.S. reports is because it matters, right? It matters what the theory of our separation of powers is. It matters how the founders interpreted text of the Constitution. In a functionalist world, it doesn't matter that much. You see, like, oh, what makes sense? Too much, too little. We're structuring it so and so, but it mattered to Justice Scalia, and over time, it mattered to a majority of the court. And then both majorities and dissents are engaging with these works.
One thing that struck me listening to Paul Clement's wonderful remarks is just the range of influence the justice had, particularly Paul's mention of class actions, which is a topic we could have a whole panel on. And once again,
I hope not.
we were not going there, but where I am going with it is that, and Steve mentioned this, is Lujan, which was a critical Scalia opinion, a critical opinion for the court and frankly for the lower courts. And can one of you or all of you maybe speak to the influence of that particular opinion and how that is integrated into the justice's theories of separation of powers, executive power?
I was going to repeat what Steve said earlier, which I thought was a great insight on that, which he was saying how that does interface with his theory on Article 2. In other words, it's a restriction, it's a formalist, restoration, so to speak, of the judicial role as to Article 3, but it also does intersect with Article 2 and what is the scope of Article 2 powers. So I thought it was a great insight you said earlier.
Yeah, no, I think, again, it clearly, once again, the justice is wrestling with what is the judicial role, right? And what is the role of party presentation? What are the role of parties in going to courts and the like? And expansive doctrines of standing allow anyone to come into court and allow any court to sort of supervise decisions of the executive branch, departments and agencies and the like. And so reaffirming the case and controversy requirement, reaffirming standing is vindicating the separation of powers, putting the judiciary in the right box, and also restoring the accountability and the importance of the president to take care that the laws are faithfully executed.
Let's talk a little bit about the arc of Justice Scalia's thinking on these issues over time. And were there any ways in which you think the justice made adjustments or changes in his views on any of these issues?
In textualism, I think he got more rock-ribbed as he got older and tougher-minded. And I think you see that in the next generation of being kind of more strictly textualist than maybe he was when he started out. In originalism, I think he clarified his thinking on originalism towards a specific public meaning theory of originalism. But by and large, you're seeing insights for the ages in his early judicial writings. So I think there were sort of adjustments and clarifications, but I don't see a sort of any dramatic sea changes.
And he got allies.
But that's
right?
a big one.
I think definitely as he was building on what he did in the early years, he sort of elaborated in more detail. But obviously, the advent of Justice Thomas, most importantly, and then ultimately later in his career, Justice Alito, the Chief Justice, and the like, allowed him to kind of build on this, and he started writing majority opinions on these subjects.
Yeah, there's this rumor that he was going to change his mind about Chevron. Right? There's this allegedly this unpublished opinion that's out there that he was going to issue, changing his view on Chevron. I think that would be a really interesting if he was going to do that. And we'll have to wait for the opening of his papers someday. I don't know when that's supposed to happen to see whether he's rethinking that. But he was an early supporter of Chevron, both on the lower courts and then on the Supreme Court. And I think he agreed with the view, Chevron. For those of you who are not administrative law scholars, and you should thank your lucky stars you are not. But Chevron is this idea that's now finally been overruled that you would defer to the interpretations of the agencies as to their authorizing statutes. The Reagan judges, they believed that this was both a matter of giving power to the experts in the executive branch who knew how to administer these statutes, but also that it was a matter of democratic accountability, that it would place in the executive branch who the American people elected the policymaking authority rather than somebody else, primarily the courts. And I think Justice Scalia, like this court, has changed from that view, which was, I think, very pro-executive, obviously, to something that's going to place a lot more responsibility and policymaking power into the hands of the judiciary. And I think while he was on the bench, he didn't take that view, but there's always been this rumor that he was going to change his mind about Chevron and might well have joined the Loper-Bright case had it come up toward the end of his career.
Well, let's just assume that's true, or at least there's some softening of enthusiasm towards it by the end of his career. What do you think is contributing to that?
I think this is also true. I detected in the opinions of Justice Thomas too, which was I think the Reagan, Bush judges, when they first got onto the bench, they thought they could fix the administrative state, that there were problems with it, but it would be fixed. I think now you're seeing opinions that say this was maybe a mistake. The idea, not the idea that there's an executive branch with agencies, but the idea that you could have these technical expert agencies that would be, I'm not saying you should argue this later this month about the Federal Reserve, but that should be insulated from politics so that dirty politicians couldn't influence the technically correct decisions of the agencies. Is very much the Wilsonian progressive theory of the administrative state. I think both Justice Scalia and Justice Thomas, I think there's reasons why they're the leaders of this effort, I think, because they had both been in the executive branch, and I think had witnessed some of the perversities of what was going on within the executive. And so I think it's maybe not a surprise they're the ones who start challenging the idea that these agencies should be independent. In Justice Thomas's case, challenging the breadth of authority that they're granted or that they're exercising in addition to their independence. And I think I'd be curious, why did the conservative judges come to have such a hostile view to the administrative state when they didn't in the 1980s, in the early 80s?
Yeah. Go ahead.
You go ahead.
I was just going to say, I think, when Chevron was adopted, Chevron was also a doctrine about limiting judicial power, right? The idea was that the D.C. Circuit in particular, in those days, in the 80s, was supplanting its judgment for the judgment of executive agencies, whether, expert or otherwise, but they were politically accountable. And the judges were making determinations and second-guessing determinations under arbitrary and capricious and relevant factors and all these matters that should better have been made by the executive branch. What happened, I think, the implications, which maybe weren't sort of foreseen in the late 80s, but I think Justice Scalia basically he didn't write Chevron, but he made Chevron, right? Justice Stevens wrote the Chevron opinion, but nobody thought Chevron was a sea change until Justice Scalia started talking about the importance of deference and what Chevron should mean, and you can see this in the citations and the like. But over time, what happened was Congress stopped passing laws, and every administration was spent with proposing regulations to sort of implement the new administration's agenda. The next administration, when the party switched, was spent reversing what the last guy did. And so you had things like net neutrality bouncing back and forth. You had the Obama administration's Clean Power Plan, which was litigated through Trump 1, trying to get rid of it, and then only to come back. West Virginia versus EPA, the major questions doctrine case, was a Biden administration Supreme Court decision about the Obama administration's Clean Power Plan, 8 years before. And so what Chevron produced was that if the agencies could just make it up or gap fill through ambiguous statutes, the agencies were really doing the legislating. And I think that's where the conservatives kind of lost it because it made a mockery of what is the law? What are the laws that Congress has adopted? Really what we were talking about is agencies ping-ponging back and forth depending on presidential administration. And I think that Justice Scalia would have shared the views of folks like Justice Gorsuch, Justice Thomas, Justice Kavanaugh, and others who sort of decided to get out of that business, in Loper Bright.
And then maybe just a footnote to that. My administrative law professor was another Scalia clerk, John Manning, and he gave a lecture about Chevron, and he was kind of commenting on why did Justice Scalia, love Chevron. He said when they're in the D.C. Circuit, they have to use it as a verb, to chevron. It's like they get a big administrative case, and he'd, say to the other judges, well, can we just chevron it? Let's just chevron it. So maybe it was a docket clearing thing too, but he said, look, in Chevron step 1, you had to discern whether or not there is ambiguity in the statute. And of course, Justice Scalia never thought there was ambiguity. He had very, very strong views on he had very powerful theories of statutory interpretation. He usually could settle it, and whereas then on step 2, if there really is ambiguity, then he viewed that ambiguity as as an intentional delegation by Congress to the agency. So Chevron made sense. Now, you put Chevron step one in the hands of judges who aren't that serious textualists who can find ambiguity anywhere, then you end up with kind of opening the floodgates. And you saw in practice this. I mean, the ping-ponging point is an excellent point, that the agencies are shifting back and forth. And again, in Loper Bright, the insight is this is fundamentally the role of the judiciary, not the role of the executive branch. We can see how, he was very attracted to the Chevron framework as, someone who had very, very strong views on statutory interpretation, usually could discern exactly what he thought that statute meant. And then when he couldn't, there really was grievous ambiguity, and that is a situation that should be interpreted as a delegation. That was Professor Manning's view on it, probably based on some personal conversations, based on that story about two Chevron, which I thought was really funny.
The phrase faint-hearted originalist is one that we kept hearing, and we can debate what it means, but when you read Morrison v. Olson, it doesn't read particularly faint-heartedly. And so I guess the question I would have for you, all of you, is does this label apply in any way to the justices' thinking in the areas of separation of powers and executive power? And one I might raise is the non-delegation doctrine, but perhaps there'd be others that you might comment on.
I'm going to skip the non-delegation doctrine.
Yeah, I mean, I think like with anything, as to the non-delegation doctrine, I think, the non-delegation doctrine makes perfect sense as a matter of constitutional principle, and then it all breaks down when you try to figure out how to apply it, right? Like what's too much? And actually, I think the justice wrote about this in his Mistretta dissent, if I recall. But I mean, it's hard to, and the one thing Justice Scalia likes is rules and clear standards that eliminate judicial discretion. And so something like the non-delegation doctrine, it's got to be pretty out there to bring it to bear. But I think to some degree, doctrines like the major questions doctrine are approaching that kind of purpose. And then just on the faint-hearted originalist, I think part of that was about whipping in the public square, but part of it really, what I think he was probably saying is judges have to exercise judgment. And there's a host of considerations that come in, including stare decisis, which is also an important virtue under the law, and how you balance that against getting the Constitution right from an originalist perspective is always going to involve a certain degree of discretion, judgment, and sort of figuring out what makes sense in the case that's before you.
Yeah, I agree. I was thinking, in response to your question, Judge, is a good example of what you're talking about and what Steve just said is Justice Scalia's vote in the line item veto case. He wasn't in the majority, he was in the dissent. And I think that's because, which is surprising when you think about it, right? He thought that Congress could give the president the power to do line item vetoes. And I think the reason, and it's always puzzled me when I teach separation of powers law, why he voted that way in this case, because it seems out of step with his formalist approach to the separation of powers. But I think it's for exactly this reason. This is the thing troubles the court now. How do you draw the line in what's sufficient delegation and what's too much delegation? It's much like I would say Justice Scalia's opinion is maybe in the takings clause too. When is a taking too much? When is regulation reduce the value of property too much to be a taking? So remember, he wrote the opinion in Lucas where he said, if it's 100% loss of value, that's clear, we can tell. But he doesn't say anything about what if it's an 80% drop in value. So I do think that I think like a lot of these judges who are educated in the years after Brown, this question of the judiciary should only be taking cases where they can draw a clear line. Or as John said, the rule of law is the law of rules is the name of his famous essay. I think that came for him before you got to originalism. Rather than originalism tells you have to decide this case and then the judge just figures out the line no matter what. I think he would rather say those are political questions, maybe, or things that are not suitable for judicial resolution, like the way the court has done in the congressional redistricting cases. This also brings to mind one thing that I talked to him about driving around in the car. Was I actually I asked him
who was driving you?
I would never let him drive. I don't have a death wish. Are you kidding? In Sicily, apparently red means go faster, not stop. I actually would ask him. I was like a 25-year-old guy, and I was asking. I have no idea. I had no sense of propriety. So I was like, what do you think you're going to be known for? I would ask him stuff like that. So he said, I think the thing I will most be known for will be, and he said this was really surprising, my statutory interpretation cases. But to him, that was a separation of powers issue. All these methodology questions, originalism, textualism, to him, they were judges properly performing their role. I think he was an originalist because he thought that was the best way for judges to interpret the Constitution. But it was the judge's role first. And so in statutory, he was criticized because it seems like an inconsistency, because in legislative interpretation, he said, don't look at legislative history, right? But with constitutional interpretation, he essentially said, look at legislative history. And I never heard from him exactly how he reconciled the two. There's a lot of law review articles that try to do it on his behalf. I don't know which ones are speaking for him or not. But I think in both cases, the reason why I adopted originalism with the Constitution, but textualism with statutes, is because that minimized the policymaking role of the judiciary in those discrete settings. And that always, I think, came first above, right, faint-hearted or strong-hearted originalism.
I'm just imagining you gripping the side of the car. I did justice once. We had an end-of-year party, and he said, "Well, just follow me on the GW Parkway. I'll show you where I live. Just follow the green Beamer that he drove at the time." And that was the fastest I think I've ever driven on the GW Parkway.
I mean, let's not forget the fact that apparently Justice Scalia used to play squash.
Yeah. And he was really competitive, like down to the very last point. He would fight all the way, cursing, yelling in Italian. I mean, words I'd never heard before and never want to hear again.
Let me ask you all about federalism. So we've talked a lot about separation of powers, executive power. Some have said, the justice was more focused there. He was less focused on federalism, even though he was on the court at a time in which Chief Justice Rehnquist was certainly pressing these issues, and the justice was also the author of Raich. So how do you kind of align where the justice was going in separation of powers and executive power with what he was doing or not doing in federalism?
John, do you want to go ahead? You actually live in a state that believes in federalism. You're from Maryland? Not mine. So this is interesting. You mentioned Prince as an interesting case where he kind of took a federalism case and turned it into a separation of powers issue. I do think, he famously testified during his confirmation hearings that, the Bill of Rights gets all the attention, but remember, to him, the most important provisions, he doesn't say the separation of powers, he says the structural features of the Constitution. And I think he very much believed federalism was part of that. And even in the Reich case, where he upholds Congress's Commerce Clause power to criminalize all drugs, and Reich is a case where one woman grew a marijuana plant and gave it to a friend, and that's covered by the Commerce Clause. Of course, this case, the facts arose four blocks from my office in Berkeley. So this is not a surprise to me that marijuana seems to rain down from the skies freely for everyone. So notice that he tried to find a textual hook for it, right? So he didn't just say, the Commerce Clause, aggregation principle, blah, blah, blah. Remember, he said it's got to be the necessary and proper clause attached to the Commerce Clause. And that was a very innovative way to think of it. It reminded me of the way he approaches the separation of powers, again, looking for a textual hook and delving into the meaning of the clause, the necessary and proper clause, rather than just sort of buying into federalism doctrine as it had existed and just accepting it. And so in Prince, I thought I think this has had a very profound effect, I think, in the workings of the government, certainly in the immigration controversies we're having today, the idea that state officers cannot enforce federal law, right? And federal officers can't enforce state law. That was not clear before Prince. And right, even though it's a federalism case, he finds the reason for it in the separation of powers. And so to me, I don't think he downplayed federalism. I think it's more that he thought of both of them in much the same way and used the same method to try to decide both sets of cases.
Yeah, no, and I think maybe to some degree the faint-hearted originalism may come in there too. I mean, because obviously Prince was a decision in which he thought hard on and applied originalist principles. There's a lot of history in Prince. But when I think about race, you think about Wickard, and you think about the modern federal government that has grown up around the post-1937 Commerce Clause. And so I think he was trying to reconcile text and provide a sort of constitutional foundation for the holding in race. On the other hand, I wouldn't call it his most originalist of opinions, but to some degree, it's okay. But if you pull that open, where do you stop? And that's also not something that he was looking to do.
So where the justice's career began were with two solo dissents, in Morrison and then in Mistretta, and those were probably his two most significant writings in the late 1980s, and obviously reflected a great deal of judicial courage to be writing what he wrote and by himself. And you fast forward now, and many of these ideas, as you've discussed, have gained much greater traction. Why have they gained traction? What about the ideas has persuaded people?
I'd say I'd point to two reasons. One is they're compelling, right? It is it's a unified theory of judicial role, of the meaning of the Constitution, of how to interpret texts. What is authoritative, what is binding, what is authoritative source of law. So it's a unified and compelling theory. But also there's been the work of countless people in sort of building a sort of legal culture in parallel with it that's receptive to those ideas. Organizations like this and many other organizations that have worked really hard to sort of get into the law schools and make sure these ideas are disseminated. And on that front, of course, one of the things the justice loved doing is going out there and selling his own ideas. And so maybe you could, one factor there was his own personal embassy. I mean, he would accept, at least it seemed to me, and I know your year, we had the Scalia Clerks Union, your year, they did the roast of the justice where there was just a cardboard cutout of the justice that year because he'd just been flying around and giving talks everywhere the whole year. They'd never seen him, so they took a cardboard cutout of the justice out to the mall and were like hanging out with it and smoking cigars with it as the joke.
That's a wooden cutout, and by the way, do you know where that is? That's in my Chambers conference room.
Oh, so, that's good.
You want to come and find that.
So I remember hooting with laughter. But he was out like on a speaker circuit, so to speak, because he wanted to sell his ideas, to persuade other people of his ideas in real time when he was alive. Being a professor was always a strong strand in his personality. He was out in the law schools, convincing law students of his ideas and sort of bringing in a generation of clerks who would be influential and all that. So I think, one factor I'd point to would be his own, personal ambassadorship for his own ideas, which he was always the most engaging speaker, always delightful to listen to, always humorous and engaging, but always pushing, a unified and highly convincing vision of how we ought to think about, the most profound questions in our legal system.
And to add to that, he clearly was an evangelist who was out there, but his writing, right? Conservative and liberal law students, when they open up the case book, all are reading the Justice Scalia opinions, whether they agree with him or they disagree with him. He was evocative, he was interesting, and he was just a terrific writer, and I think that had a real impact. And then, I think it doesn't have to be value neutral either, right? This is like, what was the last great book expressing a sort of theory of liberal jurisprudence? When
was the first one?
Right. When I was in law school at Yale, Justice Brennan gave a speech in the 80s or something, right? But nobody writes and thinks like Justice Brennan anymore in the sense that judges should be, making the society a better place. Like Justice Scalia and those who, write and think like Justice Scalia have been winning the jurisprudential debate. They've been, people are embarrassed to cite legislative history. People are embarrassed to find, substantive due process and the like. And, Heller is joined on the history, with Justice Stevens in dissent. And so, there's, ideas do matter. And there is a legitimacy and a coherence to the ideas that Justice Scalia wrote about and that others write about that, it's just not I don't think it's matched on the other side of a sort of bold vision of what it means. On the other side, Justice Breyer has wrote a couple of books articulating his jurisprudence. Nobody's really talking about them, and I don't mean that to sort of insult him as such, but the sort of liberal pragmatism, that doesn't have the same kind of heft that and the same kind of appeal to democratic legitimacy that originalism and textualism have. And so I think that's, part of his success as well.
One thing, again, thinking about my 25-year-old smart-ass version of myself, which is not that different from me now. So I'm driving around the car, and I remember asking, I can't believe I said this to him. I said, but this is before all these decisions, this is before he won all these cases, right? So I was saying, Justice, you seem to lose a lot of cases. You're not really persuading people on the court. Are you really writing your opinion? I was asking as a writer, are you really writing your opinions to persuade anyone in the majority? He lost 8-1, 7-1 in these cases. And I remember him distinctly saying, I'm writing my opinions for law students, because he wanted to change the legal culture. So he was writing for people like you guys, right? People who would become the judges, the solicitor generals, the partners in the law firms, government officials 30 years from now. And I was really struck by that. I asked Justice Thomas the same question. Again, unfortunately, Justice Thomas could fire me. Scalia could not. I can't believe I asked him that. And Justice Thomas would say, I want the opinion written for the normal, average American, not a lawyer. But Justice Scalia was writing not for lawyers today. He was writing for the future lawyers. Because, as you guys said, I agree, he wanted to change. He was very ambitious. He wanted to change the legal culture. The other part of that, I think he thought, was engaging the academy in a way a lot of conservatives don't want to, or don't feel is necessary. I bet if they did an empirical count, I bet Scalia quotes and discusses law review articles more than any other justice. Not as authority, but because he's engaging with the ideas that he finds in law review articles. I remember the year I clerked, there was an article by a law professor. I'm not going to name him because it would make his big head bigger. But there was this great article about the text of the Fourth Amendment and whether it led to the, right? It would lead to.
Who could that be?
Who could that be? Well, there's a lot of people who fall that. So it was, and it mentioned, well, if you look at it, it doesn't actually require a warrant for all searches. And so why is there an exclusion? I remember Justice Scalia mimeographed this article personally my year and handed it out to all the clerks because there was no cases pending about this question. He just thought it was really interesting. And I think that was another thing I think that we could do more of, and that Justice Scalia really, I think sometimes I used to think he was a law professor throughout and just happened to become a justice because he kept writing law review articles, he kept speaking at law schools. He was one of the main reasons the Federal Society became such a success on campuses. So this broader project, I agree, to change the legal culture, not just be justice just deciding cases. Where he writes, the books about legal writing and Black's Law Dictionary. Right? It's amazing how far his influence goes, not just because of the opinions, but because of all the external outlets that he found to be able to spread his ideas.
It always amazed me, actually. He would have very heavy weeks at the court, and then you would find out, like on a Wednesday night, that he was flying somewhere not that close, to go and speak. And the appearances were not just, casual, quiet events. He would draw hundreds of law students. He didn't necessarily limit himself to the top law schools. He did visit those. But he also went out, I remember my year, he went to the University of Denver, and he spoke there, and it was like the biggest thing that had ever happened, and it drew hundreds and hundreds of people. And I can't imagine it was a relaxing experience because he would have students that would come to the microphone and assault him and pelt him with angry questions. And he seemed to, enjoy it somewhat. And then he would come back, or he enjoyed it a lot. And then he'd come back and do it again. It was really impressive. Let me ask, and we can maybe exempt John Sauer from this, but not necessarily. We'll decide. What parts of Justice Scalia's vision, especially in the area of separation of powers, executive powers, are unrealized? What parts of what he was seeking have not been achieved and that he would want to see achieved? That's why I exempted you.
You can help him fulfill his very dreams.
Just can't think of any right now.
Go ahead.
So I think one division within people who write about presidential power, I call it the Human Resources Office version of separate presidency, or the substantive vision of the presidency. So I think a lot of the writing about the removal power, about Justice Scalia's opinion in Morrison, is about the president kind of being the chief personnel officer of the executive branch, able to hire and fire. What he didn't write that much about, and the court hasn't, honestly, is when the Constitution vests the executive power in the president, what are the substantive powers that are included with the executive power, not just this kind of management of whatever agencies Congress chooses to create. So I think when you read Morrison, I think you see hints that he thinks that the substantive powers of the presidency are quite robust, but he doesn't talk about them that much. So for example, he makes the claim there that prosecution has got to be an executive power. He doesn't, he then, I think he suggests, that the president must control subordinate officers through the ability to fire, to control the execution of federal law. I don't think he thinks of it just because that's the take care clause. I think he thinks that prosecution itself is just included in the executive power, but he doesn't go into it at great depth. And the other opinions of the court's other presidential power opinions that we've been talking about are really still focused on the removal power and not so much on other aspects. And I think he was, for example, if you want to talk about my topic I write about, but the war power, that being within the executive power under the Pacificus interpretation of the clause. I think Justice Scalia agreed with that view, but more from his time at the Justice Department rather than any case he had as a judge. Although I think if you look at his opinions in the war on terror cases, the second war on terror case, he does make a vigorous argument for the president's commander-in-chief authority. But I think that's where the Scalia agenda, if there is such a thing, on presidential power is still yet to come, is the second question. What is the substantive power of the presidency?
I think, and just to pick up on this a little bit with respect to the war on terror cases, I mean, one of the things we're sort of assuming, and I think mostly correctly, that Justice Scalia put forward a robust view of executive power. And we say, what is the power? It's all the power. But now, what does that mean is a different question. But there are cases in which where Justice Scalia would have the president lose, right? If you want to talk about, I mean, you think about Hamdi, right? And Hamdi was a case where obviously he was on diametrically opposed sides from Justice Thomas. And his view was that citizens who wage war against the country have to be prosecuted as traitors, and they cannot be detained indefinitely as enemy combatants. And Justice Thomas, deferring to the president and the president's war powers, took a very different view, and the majority came with a sort of due process balancing that yes, they can hold them indefinitely, but they need more due process and the like. But Justice Scalia said the Constitution says if you want to hold citizens indefinitely, Congress has to suspend habeas corpus. And so, in his view, had it prevailed, President Bush would not have won in that case. And another case like that is Noel Canning, where again this was about the recess appointment power, and Justice Scalia would have read the recess appointment power very narrowly. The majority read it fairly narrowly, and much more narrowly than the Justice Department had read it for 115 years or so. But he was motivated by text. Text says when a vacancy happens during the recess, and that text must mean something. And so, at the end of the day, Justice Scalia has a robust view of executive power because he believes that is the framers' conception. That's in the Federalist Papers. That's in Pacificus. Don't worry about Helvidius and James Madison and the like. But it's ultimately the text in the Constitution, I think, that controls for him.
We'll open up to questions in a moment, but I wanted to ask Professor Yu and Steve in particular about OLC, because the justice clearly loves his time working there. When I was clerking for him, he went back to a brown bag lunch there that they invited him to, and honestly, he seemed very much in his element and extremely happy to be back there. And so from your time working in that office, I don't know if you had occasion to work with opinions he wrote or otherwise, but what can you tell us about that?
Yeah, no, look, I mean, OLC is kind of a lawyer's job, and for someone who's interested in the separation of powers and in the federal government, it's really the best place you can be. And Justice Scalia certainly felt, remembered those years and kind of referred to them in conversations and the like, and would go back there for brown bag lunches. Sort of the interesting thing about Justice Scalia's tenure is he actually didn't write a lot when he was at OLC. Part of this was because he actually testified a good deal in these sort of post-Watergate period. And when he wrote, they tended to be fairly short opinions, actually, which is in contrast to Bill Rehnquist, who has some lengthy opinions that OLC has continued to rely upon for decades since. But when he wrote, it was consistent with the voice of Justice Scalia that that would be there. From my experience being at OLC, I mean, what I looked at, I think, my principal deputy was a Scalia clerk. As you mentioned, my wife is a Scalia clerk. The rest of my deputies were Thomas clerks, which is not bad.
Well, someone's got to do the work.
The question for me was Justice Scalia as the model? What would Justice Scalia do when we're confronting these constitutional questions? What is the right answer with rigor and text, history, and the like? And that was definitely a sort of guide for us. And then also integrity and fearlessness. And these are values and sort of attitudes that Justice Scalia has, bequeathed to lawyers for decades since, and still will.
So one story and then observation. So as I said, I clerked for Larry Silberman, who was the Deputy Attorney General in the Justice Department when Justice Scalia was the head of OLC and Robert Bork was the Solicitor General. I mean, can you imagine working at such a time? So he told me this story once, which I think I can now tell now that they're all dead, is that he says Scalia and Bork would get in the most terrible arguments about things, about very small issues of law, which really didn't interest Silberman very much. And so they would have a meeting. The Attorney General at this time was a former senator who, let it be said, liked to visit his home state a lot. So he basically told Judge Silberman, you take care of these disputes. So apparently Judge Silberman told me he would have a meeting with Justice Scalia and future Justice Scalia, first Judge Bork, argue their points. And then Judge Silberman said, okay, wait here, I'm going to go find out what the Attorney General thinks. He would go take the elevator to the Attorney General's office and smoke a cigar by himself in a room for 30 minutes. And then he would come down from the elevator and say, Scalia wins. I bet when he told the story to the Bork clerks, he would say, Bork wins. But apparently he said, never tell Scalia and Bork this while they're alive. So that's my story about how things get decided at OLC. I share, Steve was the Assistant Attorney General, I was a deputy. I don't remember any particular individual Scalia opinion, although there was this, as you mentioned, Steve, there was this opinion about rescuing people at the end of the Vietnam War. That was very short, that gets cited now and again. But I think the way you see his importance is, we'll see when I was there, is one, it was clearly a formalist office, right? I'm not talking about wearing ties and jackets to work. It was no functional balancing tests at all in any area on any question, right? It was all, at least in the Bush OLC, clear, bright line rules because of Scalia's law of, right, the rule of law view. And then I think also, and this I think also comes from Scalia, less deference to Supreme Court opinions. So I think OLC in my time, the idea was get the answer right first, and then see how does it match with judicial doctrine. When I think we came in, the Clinton OLC, they thought they were still clerking at the Supreme Court, these guys. Right? They thought the opinions were all, well, Justice O'Connor would balance it this way, Justice Kennedy would balance it that way. And I remember when we came in, we were just like, no more balancing tests. We're not trying to divine what Justice O'Connor thinks about this question. We're very Scalia-like, figure it out from the original meaning of the Constitution.
So I think we have microphones if there are questions, and let's just make sure you use the microphones and just so it's captured. So who has the microphones? Okay, go ahead and bring them over to people and let's hear the questions.
Thank you. Brian Fitzpatrick, good to see everybody up there. I think if you look at some of the decisions that the justice made about where to speak at law schools, it was often connected to where he could do a hunting trip at the same time. So that may explain the University of Denver, possibly. Honestly. My question is this. Do you think that there is some tension in the separation of powers area between Justice Scalia's desire for formalism and bright line rules and originalism? As Professor Yu noted it earlier, when Scalia was setting out his views on separation of powers, his very formalist views, there wasn't a lot of scholarship yet on the history. As the scholarship on the history has arisen, do you think it's a little more complicated than the firm lines of separation that Scalia was pushing from the very beginning?
No. I haven't read these articles you're referring to, but you've got Justice Scalia here and hundreds of law professors over here. I don't think that's a close balancing. So I think let me put it this way. I think the Morrison dissent lays out insight after insight after insight on how we should think about the separation of powers. And I think it's not a coincidence that, people are, as Paul said at the beginning, people are quoting it again and again and again. And there has been, I mean, not straight too close to currently pending cases, but obviously there was a lot of debate about, what really happened in the decision of 1789. But if you read Myers, actually more than half of the opinion is about sort of the liquidation that happened after the decision of 1789 and how even those who opposed what Madison kind of shepherded the first Congress to came to accept it as this is now a decided question. So I'm not sure that, if you look at, again, Judge Scalia's, three-judge per curiam opinion in Sinar against the United States talks about, the decision of 1789 and Myers. It argues that Humphrey's executor is wrongly decided, or at least strongly implies that. Apparently, I didn't know this, but apparently, according to the papers, Chief Justice Berger circulated a draft of Boucher that called into question Humphrey's executor and said Myers is the better analysis. And Justice Brennan wouldn't join it and said, no, this is terrible, you have to take it out, and he did. But it's interesting how that line of influence was already occurring. But I know that I'm sure there is a lot of scholarly commentary and debate, and one of the things the Justice did very well is invite and open the doors to that kind of scholarly commentary and debate. But the fundamental insights that he had, early in his career as a justice and as a judge, I think are lasting. And I think they're going to continue to be influential.
Let's hear a question on this side of the room if there is one. Yeah, let's bring you a microphone. So.
Hello. Basic question which traces back to Western legal history. Concerning Justice Scalia, in your opinion or any of the opinions up there, which one of his rulings could trace its way back to the Code of Justinian Code?
I got an idea. This is such a hard question.
So there we go.
No, I was reading he has this opinion about the confrontation clause. Right. And he quotes the Bible, and then he quotes the idea that the Roman citizen has the right to be faced by his accuser. And I was like, I didn't see that in the text of the Constitution. But, right, that's the example I was thinking, where he traced the principle all the way back to the Roman law.
Right.
Yeah.
Emperors and.
Yeah.
Of course, that may stir up a no emperors rally rather than a rally.
But there is this interesting question. I was sometimes when I teach, I give people, and it's really worth reading. Justice Scalia, this point about going to the lion's den and arguing with people. I think he loved that. There's this great transcript. He went to speak at the Vatican before, an audience of natural lawyers, basically, who kept asking him, how can you believe this positivism? There's got to be some moral basis for the law. And he would not give an inch, onto his view that, you carry out the enacted law of the people or you resign as a judge. But so even in a room full of Roman law lawyers at the Vatican, Justice Scalia wouldn't bend the knee, as it were, to Caesarism.
Right. There you go. Thank you.
Yeah.
Yes, sir. We'll bring you a microphone.
Well, first of all, this is a terrific panel. Thank you. And AEI is a terrific host, but I fear I'm going to be a bad guest. A point and then actually 2 points, each of which implies a question. First of all, I think it was Professor Yu who made reference to, the influence of, Pacificus, those papers on Justice Scalia's views. I have no reason to doubt that. But of course, that's one hand clapping, because that's part of a debate between Hamilton and Madison. Madison styled himself Helvidius. And I would invite everybody who's interested in the question to read that debate and conclude that Hamilton was the clear winner of that debate. In my judgment, he was not. And that there is much to be said for Madison's more constrained view of executive power. That's point number one. Point number two.
Can I answer that point before? Because
Yes.
by the time you finish your second point, I'm not going to remember your first point. But I totally agree. The Pacificus Helvidius debates are wonderful reading. The Liberty Fund actually has a book that you can get for free, essentially, that pairs them up. But the view of historians is that Hamilton won. If you look at the writing between Jefferson and Madison about it, they think Hamilton won. Hamilton, of course, always thinks he won. Right. But in actual practice, didn't Hamilton win? So Hamilton is arguing in the Pacificus Papers that the president has the right to decide whether the United States is going to be friendly to France or hostile to France after the French Revolution. Ever since that debate, we don't think that it's Congress's job to be the primary diplomatic spokesman for the United States. That is, in fact, and Thomas Jefferson, when he becomes president, he's even more pacificist than Washington was, right? I mean, he was, and Hamilton predicted this. He actually said, right, when he was choosing between Jefferson and Burr about who should become president in the contested 1800 election in the House, one of the reasons Hamilton gave to his supporters in Congress, he said, you watch, Jefferson will be a greater user of presidential power than even John Adams was. To me, that means it sounds like Pacificus even persuaded his opponents.
And there are songs about all this. Just if I may, just you can't take history seriously without recognizing that almost as soon as the ink was dry on the Constitution, there were political debates over the Washington administration and the Adams administration and thereafter. And there were two sides of the debates, including people, both of whom, like Hamilton and Madison notably. Jefferson, I care less about his views on the Constitution, but Madison was there, and Madison was heavily involved. Jefferson, at least before President Jefferson. But what you have is, you have liquidation, right? You have settlements of these questions from these early debates, in which from an early period of time, including under the aegis of George Washington, that decisions are made about what the Constitution means and what it should mean. And then you have now approaching 250 years or 239 years or whatever of history about that. And so to some degree, I mean, these debates are interesting and some of these questions were unsettled, but there were winners and losers, and there were sort of constitutional settlements that the American people have lived with over 2 centuries since.
Well, there's a lot more that I could say, and indeed but I'm not going to say it because I don't want to soak up all the airtime. Here's my second point. Reference has been made both to the Morrison dissent and to the role of the Federalist Papers in Justice Scalia's thinking. And right at the beginning of Morrison, Justice Scalia, if I recall, quotes from Federalist 47, to the effect, separation of powers, how essential and important it is. But if you go on to read the rest of Federalist 47, Madison is actually making a much more complicated point, namely that in American constitutionalism, powers are commingled among the branches. That is the argument he's making. And I don't think that that argument is consistent entirely with the kind of formalism that has been put forward on this panel. But so I would invite people who are interested in what Madison actually said about separation of powers to reread Federalist 47, because of course everybody in this room has read it, and then decide for yourselves whether it is a straightforward formalist, bright line separation. Because I don't think that that's what Madison.
I think in the Federalist Papers you have several authors. And I think it's quite fair to say that Justice Scalia, I think, agrees more with the Hamiltonian view. And if you read Hamilton's part of the Federalist Papers, which specifically talk about the presidency, I think it's very similar to what Justice Scalia was writing in Morrison and Mistretta and cases like that. I think Madison in Federalist 47 and then 51, he's talking about the overall design of the separation of powers and federalism, the way they work together. And he does have this idea of balance. I don't think Justice Scalia would ever say that one branch should dominate the other branches. I do think Justice Scalia believed in a balance of the branches. He actually thought it had gone out of whack and gone too favorable to Congress to the expense of the presidency after Watergate. And I think he thought he was bringing it back towards this Madison or Hamilton view, whichever one you think is right, but he was restoring it to the vision there. I think he thought that the presidency, and I think there's a view of many people who served in the Nixon-Ford era, that the presidency had been crippled by the Watergate changes. And that, so he's trying to bring 47, I mean, he's bringing 47 principles back to the idea that each branch is going to be sufficient to defend itself against the others, rather than one being dominant over all of them.
And I don't think there's any inconsistency between saying that there's commingling and there's formalism, right? I mean, there's commingling, right? The president appoints with the advice and consent of the Senate. Congress creates the offices that the president appoints. Congress passes the laws, but the president can veto them. And so there is called for commingling on the, under the Constitution, but that's different from saying Congress can pass new structures that don't take away too much executive power, or we balance this out, or we create the Sentencing Commission, which is sort of in the judicial branch, but we have lots of people there, and then they prescribe, guidelines and things. And so that's the commingling, that's the functionalist kind of breaking down of the text of the Constitution and the separation, I think, that Justice Scalia is talking about, rather as opposed to the structural, textual balance, commingling that the Madison is talking about.
Thank you all. It was a great panel. Menashe Shapiro, I'm never really sure what I should use as my affiliation, but for the sake of the question, I'll say a 2L at Georgetown Law. One of the things that we emphasized is that Justice Scalia was always writing for the law students of today, the lawyers of tomorrow, 30 years from now. I think it is indisputably true that he sort of won over the conservative legal movement, he birthed the movement, and made it into what it is today. So there are lots of judges that sort of follow along in that track. At the same time, a sort of counter movement developed where he is unfairly accused of not necessarily being in favor of a unitary executive, but a unitary conservative executive, meaning in as much as Republicans are in charge or conservatives are in charge, that's what he was really doing. And of course, I think this is unfair, but it is a widely held notion. Do you think that there's something that the justice could have done, should have done differently, or that we could do to sort of restore the impression that there aren't, that the judges are not making political decisions, they're making legal decisions that may or may not have political consequences?
Look, I mean, I think it's increasingly clear that there's no way anyone, in this country can kind of make decisions in public office or in judicial office or the like without being criticized, right? I mean, we're at the point, and it seems to get worse every cycle, where the 24/7 ecosystem and now the social media ecosystem is challenging everybody's. People aren't just wrong, but they're evil or they're bad. They have bad motives and the like. And there's both sides, kind of to that. So I think that Justice Scalia was focused upon being principled and constraining judicial discretion in a deliberate way of separating him from a politician. And there are, we've talked about some of these cases here, but, in the line item veto case, he was on the side of President Clinton, and in the Hamdi case, he was, opposed to President Bush's policies. And so I think it'd be sort of ridiculous to sort of actually say that Justice Scalia was practicing politics rather than having a commitment. And, President Clinton developed, a more muscular executive. President Obama did as well. And after John is done here, the next Democratic president is going to be taking advantage of those, structural unity of the executive branch. So I don't think there's anything that one can do to sort of avoid, criticism in the arena. But Justice Scalia's effort to sort of apply rules, apply formalism, and to sort of articulate his theories, I think, is about as best as you can do.
Yeah, and maybe you could, for one kind of thought experiment, maybe you could do as a sort of an argument experiment, is say you take Justice Scalia and say, can you look at him and see in his career, did he, write opinions, cast votes that were clearly kind of against his policy preferences? And it's not hard to come up with opinions there. Texas against Johnson was his favorite one to talk about how he, voted that there's a First Amendment right to burn the American flag, and came down to breakfast the next morning, and Mrs. Scalia is dancing around humming, "She's a grand old flag," because she was so mad at him for his vote in that. And he, broke and gave the fifth vote there. That was, I think, a really tough vote for him jurisprudentially, because of course there was this history going back to the time, very near the time of the founding, the early 19th century, where flag burning had been prohibited, and yet he said there's a First Amendment right to do this. It's not hard for justice to find cases where Justice Scalia cast votes that clearly went against the grain of his policy preferences. Steve mentioned a couple others, and there are many more. Contrast that, pick your favorite, justice from the other end of the ideological spectrum and say, okay, find me an opinion or a case where they cast a vote that really hurt, that hurt them to cast because they disagree with it. I think for most of them, it's going to be a lot harder to find those. Justice Scalia is the easiest justice to find him casting votes that he clearly disagreed with as a matter of policy. And that, I think, attests to the fact that he actually was, and he was the one who was saying things like, I'm a faint-hearted originalist, I'm not a rock-ribbed textualist, and so forth. But he really had a remarkable degree of fidelity to his own convictions for someone in that role.
We have time for one more question. I think there's one over here. Yeah.
So one of the interesting aspects of Justice Scalia's separation of powers jurisprudence was the difference he had with Justice Thomas, because Justice Thomas was in favor of a much more robust non-delegation doctrine. He votes differently in the Raich case. So this is a fundamental difference, I think, about the structural constitution, I think largely driven by Justice Scalia's favoring clear rules as well as originalism. Do you see that as ultimately the struggle going forward among the conservative justices? And can you have two principles, a principle of originalism and a principle of clear rules? Is it possible to ride two horses like this, or are the conservatives going to kind of work the law pure in one way or another? And don't we see that debate in some sense going on in the current Supreme Court?
John, this is a great question, and it ties in with the last question from the Georgetown student. As people know, there's this great fight going on with the conservative legal movement involving post-liberalism, right? Should the conservative legal movement move to a world where they don't believe in neutral principles anymore, or believe in neutral methodologies anymore, like an originalism? Should constitutional interpretation be guided by values? So this, I think, is a view that's gaining a lot of popularity with law students in particular, and some political scientists. So I do think that does explain some of the difference here, because I do think Justice Scalia very much believed in this idea of neutral principles that comes out of the Harvard Law School era right after Brown. I don't think Justice Thomas is taken by the neutral principles approach to interpreting the Constitution. I do think, so let me just preface it by saying Justice Thomas likes to tease me and say I'm the moderate in the chambers amongst all his clerks. I might be the most liberal one. So that should scare people too. But he often makes fun of me for being a liberal. So because I clerked for him the year he cited the Declaration of Independence in an opinion as authority. And I told him, Justice, nobody's ever cited the Declaration. You can, it's pre-constitutional. But he I think, believes that the Constitution has to be interpreted with some attention to moral values, but those of the Declaration of Independence and of the founding. And I think the fight is going to be, how do you, once you leave the neutral principles world and you say we're going to interpret the Constitution taking into account the moral values of the Declaration of Independence, can other people import other moral value systems that they believe in, like some that are being promoted now by these post-liberal scholars? One of them, a great Scalia clerk and a friend of mine, Adrian Vermeule. I think that's one reason a lot of people might associate this view with Scalia, because one of his most prominent academic clerks is one of the leaders of moving beyond the neutral principles approach. I don't think that's Scalia's view. I don't think Adrian claims that's Scalia's view. But I do think this is that's the battle line. I agree for the conservative legal movement going forward. I really agree. But I think it's whether it can, the Thomas vision of limiting it, the import of moral values to those the founders had and announced in the Declaration, and maybe you could also say, I think, renewed in the Reconstruction Amendments. but no farther? Or is this just open the door to conservatives just saying we have power now and we're going to rule based on our moral values, just the way the Warren Court did from the other poll?
Well, it's time for a break, and so please join me in thanking this great panel. Great job.
That was a lot of
Yeah,
fun.
that was
I don't
fun.
think we've ever been on a panel before.
No, yeah.
Are you
not
going to
for
be
that
around
long.
for anything
No,
else?
no,
or do
no,
you-
it's great. It's good stuff.
If you'll all take your seats now, we'll get started with the next panel. I invite you, yes, that includes you, Judge Sutton, to take your seat. We'll all come up here, please. We'll get settled here. And Jeff, how are you? Nice to see you. We're going to get started here as soon as we get our judges up to the stage and everyone's seated. Well, thank you, everyone. If you'll take your seats, we'll get started with our next panel. We have so many former Scalia clerks who are judges that there's hardly room on this dais for me. But I want to introduce this next panel. Justice Scalia's influence on judges and on the craft of judging has been massive. This next panel consists of former Scalia clerks who are now federal judges. And what a group it is. I dare say that it may be the most extraordinary collection of judicial talent ever gathered at AEI, with the exception of when Justice Scalia spoke alone. We're going to keep introductions short, so I'll be very brief in introducing our distinguished moderator. Just over 3 months ago, on November 3rd of last year, President Trump appointed Rebecca Tableson to the U.S. Court of Appeals for the Seventh Circuit. You might surmise that she is the former Scalia clerk who has been most recently appointed to the federal bench, but you'd be wrong. Eric Tung, who can't be with us today, was appointed to the Ninth Circuit 4 days after Judge Tableson. Judge Tableson was a law clerk for Justice Scalia in the 2011-2012 term of the Supreme Court. Before that, she was a law clerk for D.C. Circuit Judge Brett Kavanaugh. Judge.
Thank you so much, Ed, and thank you to AEI. It's really lovely to be here with all my colleagues, from whom I'm hoping to learn today as well. As Ed just said, I'm new to this. Justice Scalia's influence on the federal judiciary writ large is, of course, well known. He was, as we were just hearing in the previous panel, a brilliant and persuasive writer, and he did persuade, a generation of law students and lawyers and judges about both broad methodological issues like originalism and textualism and specific substantive areas of law. But he also influenced his law clerks. He called us the clerkerati in a more direct and personal way. For me, at least, those lessons, he was a role model to me for how to be as a lawyer, as a human being, and now as a judge. And that is largely what we are going to be talking about today. We have 6 very distinguished guests here, and so it would take a lot of time to recite all their credentials, and I won't, and I apologize, I lack fun facts about each of them. But quick introductions. Chief Judge Pat Schiltz has been on the District of Minnesota since 2006. And he clerked for Justice Scalia in OT 1985 and 1986. Chief Judge Jeffrey Sutton has been on the Sixth Circuit since 2003. He clerked for the justice in OT 91. Judge Dan Collins has been on the Ninth Circuit since 2019. He was also a law clerk for Justice Scalia in OT 1991. Judge Joan Larson has been a judge on the Sixth Circuit since 2017, and she was formerly a justice on the Michigan Supreme Court from 2015 to 17. She was a law clerk for Justice Scalia in OT 1994. Judge Dan Bress has been on the Ninth Circuit since 2019. He was a law clerk for Justice Scalia in OT 2006. And finally, Judge Rachel Kovner has been on the Eastern District of New York since 2019, and she clerked for the justice in OT 2007. So we're going to go through, and these judges are going to make some remarks and ask some questions after that, and maybe take a few from the crowd, time permitting. I'll start with Judge Pat Schiltz.
Well, thank you. We are here today on kind of a sad occasion. It's been 10 years since Justice Scalia died. I'm sure all of my fellow clerks would say the same thing, which is I just can't believe it. It just seems like yesterday that I was talking to him. I take solace in the fact, though, that he did not live to see me branded a progressive activist judge throughout the world. It came as a surprise to me, probably would have come as a surprise to him as well. So I had the privilege of clerking for Justice Scalia during his last year on the DC Circuit and during his first year on the Supreme Court. And then in between, I helped him prepare for his confirmation hearings, which was a much different, it was largely a one-person job at the time. And then obviously helped him in the transition. And there's a lot that I could talk about, but I thought I'd focus on one thing, and that is when I think back to the transition from the DC Circuit to the Supreme Court, the thing that most sticks in my memory might surprise you, and that is how happy he was at the DC Circuit and how frustrated he was during his first term at the Supreme Court. And indeed, he often told me, especially in the late 80s and the early 90s, that he enjoyed the work at the DC Circuit more than the work at the Supreme Court. Now, obviously, he wouldn't have traded his new job for his old job back. He wasn't saying the work at the Supreme Court was less important. He was just saying when he came to work every day, he had more fun at the DC Circuit than he did at the Supreme Court. And again, we're talking about his first term at the Supreme Court. And I think his feelings reflected a couple of things. One is that the work of the DC Circuit was largely devoted to administrative law. I worked on so many Federal Energy Regulatory Commission cases that I was nicknamed the FERC clerk. God, that was just awful. But Justice Scalia loved administrative law. He loved what they did at the DC Circuit. And he also thought that the lawyers who appeared before him at the DC Circuit were on the whole better than the lawyers who appeared before him at the Supreme Court. A lot of them were agency lawyers. A lot of them had been with their agencies for years, and they were really good. But I think the key to understanding why he liked the DC Circuit better than the Supreme Court, at least initially, is two other factors. One is his colleagues. He had an incredible group of colleagues at the DC Circuit. When Justice Scalia was nominated to the Supreme Court, his colleagues on the DC Circuit were Judges Wald, Robinson, Mikva, Edwards, Ginsburg, Bork, Starr, Silberman, and Buckley. And it's quite a group. And he liked every one of them, and he respected every one of them. And about half of them either were close friends of his or became close friends of his. Now, when he got to the Supreme Court, 4 of the justices were nearly 80 years old, Justices Brennan, Marshall, Blackmun, and Powell, and all of them at the time had been slowed by illness or by age or both, and all of them were at least 30 years older than Scalia. It's hard for me. Now that I'm 65, he was 50 when he went on the Supreme Court, which seems like a baby to me, 50, and they were 30 years older than he was. Justices, Chief Justice Rehnquist and Justice White were also quite a bit older than Justice Scalia, and they were curmudgeonly, I guess I would call them. They didn't really like to mostly they liked to go home at the end of the day. They did not really like to talk about cases, spend a lot of time debating, and that left Justices Stevens and O'Connor, and while Justice Scalia liked them both, I don't think either really became a close personal friend of his. The other difference I wanted to highlight is the DC Circuit, when Justice Scalia was there, was a very dynamic place. The judges often walked down the halls to talk to each other about cases, and how opinions should have been written. You know, imagine a panel of Ginsburg, Bork, and Scalia, okay? You're gonna have some chatting among the judges if you have that panel. And it was really common at the DC Circuit, as I said, for one judge to walk down the hall to talk to another judge, for a judge to make suggestions to draft opinions of another judge, for judges to be persuaded by other person's opinions and change their votes. It was a really intellectually lively place in 1986. no one would call the United States Supreme Court an intellectually lively place in 1986. A couple years after my clerkship ended, I wrote a review of Chief Justice Rehnquist's book on the Supreme Court. And I noted in my review that Rehnquist spent a lot of time in his book defending his practice of discouraging discussion of the cases at conference. He just wanted them to announce their votes. He didn't want any talk about the conference, about the merits of the case. And in my review, I said that these stale conferences were just a manifestation of a broader intellectual sterility at the court. And I said, this is one of the great things about being a judge, you can quote yourself. And Oliver Wendell Holmes said, and then Benjamin Cardozo said, and then I wrote. So I said this, and I'm going to read because I think it was true. This is the Supreme Court in the late 80s. Discussion of cases among justices is frowned upon, not only in conference, but at any time. Justices rarely engage in substantive discussions with one another, and most of the discussions that do occur involve the same few members of the court. To an almost absurd degree, communications among the justices occur by means of written memoranda, shuttled among the chambers by messengers. It's generally considered bad form for one justice to ask another who has voted in the majority to await the circulation of dissent before joining the majority. And it's nearly criminal to change one's mind, particularly after one has cast one's vote, and particularly if one has voted with a 5-member majority. So imagine the Antonin Scalia that you know, even if you only know him from reading about him, being plopped into that atmosphere. I remember, for example, one time he walked down, it was a couple months after we got there, he walked down the hall to talk to one of his colleagues about a case, and was told that the justice was taking his afternoon nap and that he would have to come back later, but the justice would appreciate it if Scalia would give him advance notice when he planned to visit so that he could be prepared, awake and prepared for the visit. I remember another occasion when Justice Scalia went to a different colleague to talk about a case that had fairly recently been argued, and he got the impression the justice didn't know what case he was talking about. And then when about an hour later, we got a memo from the justice that asked Justice Scalia to only talk about cases in writing, not that the justice didn't want to talk to him about the cases orally. And then when Justice Scalia did communicate with his colleagues about matters in writing, some of them and their law clerks derided those as ninograms and made fun of him for suggesting changes in writing. So it was a frustrating place for him when he first got there, especially when you consider the contrast with what he'd come from. Justice Scalia was just passionately devoted to getting it right. That's what he called it. We got to get it right. And he counted on discussion with his clerks, with lawyers, with his colleagues to help him get it right. And he enjoyed that process much more at the DC Circuit than he did at the Supreme Court. Now, one other point I want to make, and then I'll be done. Ed Whalen asked me to just mention to what extent did I see Justice Scalia's judicial philosophy, to what extent was it apparent in the very, very early years? Now, again, I'm with him at the very beginning of his career. Most people still called him Scalia at the time, Judge Scalia. So what I would say is this. Justice Scalia had a theory of constitutional interpretation at that time, but it really had not been battle tested. As I said, the work of the DC Circuit was heavily dominated by administrative law and by statutory interpretation, and the docket was light on the kind of constitutional issues that make up much of the Supreme Court's docket. And Justice Scalia's intellectual project at that time was legislative history. That's what he was writing about in his opinions. That's what he was going out on the speaking tour on. It sounds strange to say it, but he wasn't really that focused on constitutional law when I worked for him. And so there was a lot of areas, the religion clauses or the right to counsel or excessive fines clause that he'd just never really given a lot of thought to. So to paraphrase Mike Tyson, everybody has a judicial philosophy until you get punched in the mouth. So he had a judicial philosophy, and then he got nominated to the Supreme Court. And one of the first punches in the mouth that I remember came when William Bradford Reynolds came over to Chambers to meet with him, and it was Reynolds, Judge Scalia, and me in his office. And the question was, when a senator asked you at your hearings if Brown versus Board was correctly decided, what's your answer going to be? And think about that. There isn't a good one, right? You can say, I'm not going to tell you whether I think Brown versus Board was right. That sounds bad. You can say, that was wrong, clearly wrong, worse. Or you can say it was correct. If you say it's correct, next question is, well, how do you reconcile that with your judicial philosophy then? How does the Scalia philosophy of constitutional interpretation get you to Brown? And after a long discussion, he basically, if you remember his hearings, he basically decided he wasn't going to say whether he thought Brown was correctly decided or any other case. And he argued it would be a slippery slope. So I think, though, that discussion drove home to him something that got driven home to him much more during our first year on the Supreme Court, which is it's one thing to have a philosophy of constitutional interpretation when you're on a lower court, when you don't face many hard constitutional decisions, and when you have to follow the Supreme Court's precedent. But when you go to the court and you're regularly dealing with these questions and you really don't have to follow your earlier cases, it's a much, much harder thing. So the germ was there, but it really got developed in those first few years on the Supreme Court just under fire.
Thank you, Pat. Judge Bress.
Okay, well, I want to say first, great to be here again, and just what a wonderful group of colleagues to be up here with. You know, the clerkship was a very exhilarating experience. We worked very hard, but it was fun. It was a lot of fun to go to work. And the justice, you know, I think one thing that came out in the last panel was just his focus on methodology. Of course, there was methodology within Chambers, too, and the way that he went about deciding cases. The arguments he had, the summoning of the clerkerati to come and talk about an issue, the process of writing, which I think we'll hear more about. I remember the first week I was there was a death penalty case that was coming out of the Fifth Circuit, and I was just up on the wheel. And luckily I had John Sauer there. I don't know what I would have done if he wasn't there. But I was up, and so I was working up this case, and then it got to the point where we had to get in touch with the justice, who was in Greece. So it wasn't exactly that reachable, but there was a marshal with him. And so I asked John, I said, well, now what do we do? He said, well, you're going to have to call this number, and you have to wake the justice up. And that was I hadn't spoken to the justice since I took the job, so my first call with the justice was probably about 2:45 a.m. Greece time, in which I was reading him a memo on this case, and that's how the clerkship began. There were so many great moments in the clerkship, but one that stands out, a funny moment, was there was a time that we got the message, you know, from on high, summoned the clerkerati. So we all came down, all four of us, to the justice's office. And he said, well, I want you all to line up all next to each other. I thought, you know, this is the time of the clerkship where somebody gets executed. You know, this is it. And so he kind of looked at each one of us and said, I've been invited to attend a dinner this evening at the Italian embassy, and I've spilled something on my tie. So Dan, I'm going to need you to take off your tie, and I will be wearing your tie this evening. So I thought I would speak a little bit about the justice from the perspective now as a judge sitting on multi-member panels. And so it's all fine and good to have clear and coherent theories of law. And then when you find yourself in a situation where you're not a district court judge, you have to decide things in most of our cases in groups of 3, in the case of the justice, groups of 9. And I think that anybody who starts this job realizes that is an X factor in judging, that you have to do this with other people. And so I thought I would just speak for a few minutes about some of the observations I had about the justice. And you know, I never had the chance to talk to the justice about taking on this role, because he passed away and then I came into this role later, there's so many days where I wish that I could call him and say, how would you handle this, or how would you think about this? But so I offer these reflections not really based on anything he said, but more things I observed him do during the course of the year when he's working on a court and deciding cases with 8 other people. I think the justice's first, the thing I most respected about him was that he was insistent that we get it right, and Judge mentioned that a moment ago. And he was uncompromising in that, and I don't mean that in a negative way. I mean that in a way that was out of complete respect and fidelity to the law. And what it meant was that when an opinion was circulated or when he was writing something, it could never be wrong. And he was not going to sign on to something that he disagreed with, and that was obviously, of course, true with the result, but it was down to the reasoning. It was down to the cases that were cited, and if there was something wrong in it, he wasn't joining it until that piece of it got fixed, and he was insistent about that. And I laugh to myself because I'm sitting next to my colleague, Judge Collins, and we have the same approach because we were trained by the same person. And I know that if I sit on a case with Judge Collins and I circulate something to him, I will get back whatever I get back, but it will be something that matters to him because he believes it to be right, and it's grounded in law. And that was the justice's approach. And that, of course, has effects when you're working in a multi-member body. But the justice was insistent on that from the beginning. I will say, I think sometimes overlooked with the many strident and powerful dissents is the justice's effort, at times where possible, to achieve consensus and to have a majority. And I did see the justice try to think about opinions from the perspective of, how can we write this in a way that's going to be acceptable to people? It obviously had to be consistent with his views of the law, and he was not going to bend in order to get another vote. There were many times where something went out as a plurality, and that was what it was. But there were times where he kind of saw an opening, or he thought this may be persuasive and we could write it in a certain way. And there were times where he got a draft from somebody and he thought, after discussion, there might be a way to try to work through some of these things. And the way he went about doing that, he would sometimes pick up the phone. Oftentimes, he would say, well, let me just make a phone call. And he would get the other justice on the phone and talk about that issue. Or he would say, I'm going to send a memo, about it, just give somebody a preview. And I always kind of thought, he went about those things in a very nice and respectful way, and one that was effective. The other thing that I'll say about the justice on this point is that, there were times where he got frustrated, and boy, as clerks, we got frustrated. There were times where it just wasn't going his way. And what I learned from him was that there would be frustration, and you could pound the table for a little while, but then the frustration had to end because there was always another case. It was a long game. And we as clerks, it would burn for longer than it did for him. He would move on more quickly than we did. These were things that I'm still irritated by, many, many years later. And it probably would be cases that he ranked as somewhere lower down on the list for him. But he had the ability, I think, based on experience and based on judgment, to know that there was always going to be future cases, there was going to be future rounds, and it didn't profit to be so upset that you couldn't move on to the next thing and work with the same group of people. The last thing I'll mention was the justice's collegiality, and the justice was a collegial person. He was a friendly person. People liked to be around him, and I think he made efforts to try to be friendly with people. And I think he valued that. I think he valued the idea that he could have disagreements in writing and that he could then go with Justice Breyer and do a panel together and have a good time. And obviously his well-known friendship with Justice Ginsburg, which I had the opportunity to observe firsthand. And that friendship has, since both of them passed, that friendship has been the subject of much discussion and respect. But what I always appreciated about that, from my observation, was that the friendship was not transactional in any way. The friendship was a legitimate, genuine friendship based on mutual respect. And I think the justice, really got quite a bit of joy out of that friendship. At least that was what I was observing when I saw the two of them interact together, or certainly when he mentioned her. And I always felt that, the justice had in his mind that there were going to be plenty of disagreements, but that if to have a success on a court long term, it was helpful to have some degree of friendship where possible, and I think he made efforts to that. I've told Ed this story before, but I think this also speaks to the same point. When I was clerking for the justice, there was an award given to the then Chief Justice of the Israeli Supreme Court, Aharon Barak, who had completely different judicial philosophy than the justice. But the justice was tasked with introducing him and presenting this award at the Supreme Court. And he asked me to help him draft the remarks for this. And so I was doing some research, and I put in the draft, Chief Justice Barak and I, we don't always agree on these things. We have some disagreements, but, and then I would kind of go into the rest of the piece. And the justice said, I don't want to say that because everybody knows there's disagreements. I don't need to impress them upon the audience even further. He said, sometimes I get introduced and people introduce me that way, where they say, well, here's Justice Scalia, and he has all these wrong and terrible ideas, but he's a wonderful person. And so, but I learned a lot by kind of working at the justice's feet and seeing how he approached some of these relationship issues. And these are not necessarily issues of law, they're more issues of human relations and judgment. But I think it's a piece of him that the public didn't necessarily see because they're so used to reading some of the dissents that gained so much traction. And believe me, those were hugely important to the rule of law, and I think the justice was very strategic in how he did those. But I think lost in the shuffle a little bit can be the idea that the justice, fully understood that he was a member of a court and that there were ways in which he could make his life better and more enjoyable and more effective by kind of respecting his colleagues and having relationships with them.
Thank you, Judge Press. Judge Collins.
I'd like to talk about two particular aspects of Justice Scalia that really impressed me during my year with him. One was his honesty, and another was his humor. With respect to his honesty, you could tell from everything he wrote and how often he wrote separately, concurring in the judgment in part. I join everything except footnote 4 and footnote 7. He was incredibly honest about what he thought the precedent said, what the limits of it were, and what the defects of the precedent were. And he wanted it all to make sense according to his view of the law and how jurisprudence should be done substantively and methodologically. And that was something that just really impressed me during my time with him. And in some ways it was humbling, because I remember giving him a draft once in which I did the classic lawyerly fudge. There was a line in a case that we had to discuss, and rather than take it on, I just sort of danced around it. And I had the stupidity or temerity to pass this draft along to him. And of course, the response I got was, what is going on in this paragraph? What is this? He could detect it right away that this was just not treating the precedent honestly. And, I said, well, is this kind of issue? Well, if there's a problem with it, then we'll either distinguish it or we'll say it's wrong. And that was kind of his forthright approach. And I think you could kind of see that in contrast to Chief Justice Rehnquist, who was the master of the lawyerly fudge, who could write an opinion and just distinguish and box in a case. And sometimes Justice Scalia would join those opinions, but that's not how he would ever write them. And you can look at that in a series of cases, starting with Grady v. Corbin. Grady v. Corbin was a Brennan opinion where he created a variant of double jeopardy jurisprudence that lasted for, I think, about 5 years. It basically was so incoherent it fell of its own weight. But one of Justice Scalia's, I think, greatest dissents is his dissent in Grady v. Corbin, where he has the wonderful line where he says, the majority's opinion raises many questions, the answers to all of which are ridiculous. A line I've actually quoted in one of my own dissents. But a wonderful line. And so Chief Justice Rehnquist writes the next post-Grady opinion called United States versus Felix, where he
sets out basically a conspiracy exception to the Grady rule on double jeopardy. And then he has a section in the Felix opinion where he goes through, well, the lower circuits, one of them has taken this approach to Grady, one of them has taken this other approach. We need not dwell on these niceties. And he just basically declares the conspiracy exception. Well, and then the next Grady case, which was Dixon versus United States, which Justice Scalia wrote, and overrules Grady v. Corbin. He then invokes Felix to say, well, Felix is really not reconcilable with Grady, so Grady has to go. And the much more frank approach to the subject. So I really admire that honesty, but I also, as a circuit judge, I don't feel that I have quite the same freedom to approach the law in the way that he did, because he's on the Supreme Court of the United States. He gets to say it's wrong, it should be overruled. I don't get to say that. I'm not, we don't sit every day in an en banc court. And so we don't have the privilege of saying that things should be overruled. Plus, we are bound by so much more precedent, the volume of precedent, particularly in a court like the Ninth Circuit, which has too much law. It's very hard sometimes to have sort of a grand theory and make it all make sense. The data points don't always add up. I've had one occasion to write a dissent where I just threw up my hands and said, we have two contradictory lines of cases on this subject. Here's one side, and here's what they say, and then there's another line that says exactly the opposite on two separate points. Fortunately, the Supreme Court now has the issue, and they'll sort it out. But on that one, I just threw up my hands. But a lot of times, we have to do our best to sort of, all right, maybe not a lawyerly fudge, but where you try and make the best of too much law, where there really is just too much tension in the body of law. The other thing, though, I wanted to highlight was his humor. It's already been commented upon, and it's very well known how funny he was in his writing, how funny he was during the arguments. But he was just a delight to work with for a year. He was very funny, even within the chambers and with the law clerks, and he was never too far from the next joke. I always remember one occasion when I was stayed late with him working on an opinion, and then we were wrapping up, and I walked out with him into the main reception area. And in that reception area, there was, by the window, on the windowsill, a red phone. No one ever explained to me why it was there or what it was for, and no one ever used it. But as we walked out and we're wrapping up, it happened. The phone rang. And he just turned to me and looked at me and said, I better get that. It could be Khrushchev. And he did answer. It turned out it was a wrong number. But he was just a funny person. He took the work seriously, and he wanted you to take it seriously. But he just was so much fun to be with, and a good person. And I don't try and be funny in my opinions. I don't have the gift he had, and so I don't even attempt to do it. But I do attempt in my interactions with my law clerks to keep things a little bit lighthearted, because I think it makes a high volume, high stress job a little bit easier to do. And so those were some of the things I learned from Justice Scalia.
Thank you, Judge Collins. Judge Kovner.
This might be on. Yeah, okay. Thanks to Ed for organizing this panel, and to Judge Tableson for moderating it. And it's nice to have the opportunity to think a little bit about clerking for Justice Scalia and how that was distinctive, and how that experience, I think, continues to affect how I approach judging. I should say I'm a district court judge, and so the job is quite different. Some of the dynamics about multi-member panels, obviously, that don't apply in the district court, where you don't have to persuade other people, and we're also so much more constrained by precedent than a Supreme Court justice. So, Justice Scalia could be a big ideas guy in a way that district court judges can't always be. But I think there were some sort of approaches, high-level approaches that Justice Scalia had that I think were somewhat distinctive to Justice Scalia, and I think about a lot now that I'm a judge. One of them that I think we heard about a little on the last panel was sort of about his commitment to argument, and how he would go out to law schools and kind of mix it up with law students or anybody who wanted to show up. And he was very much, that was his approach in chambers. Before every argument sitting, he would sit down with all the clerks and talk about the cases, and where the clerks had a different reaction to something than Justice Scalia, he would spend literally hours arguing with the clerks about the cases. And it was really striking to me at the time. This was somebody who had been on the bench at that point for 20 years, and we were all people who were, a year out of law school. But he was so committed to getting it right that he wanted to, hear what our best arguments were that he was not getting it right, and he was really willing to invest the time to do that. And I think now that I am a judge, I appreciate that more, because I think it can be a difficulty of the job that people don't always want to tell you things you don't want to hear. And so creating a culture in chambers where people are willing to say, actually, I'm not totally persuaded by this, or I'm not sure you're citing this case the right way, is something I think is obviously very consistent with Justice Scalia's personality, but there's, I think, a real importance to developing that culture that I think can be maybe not the default for a judge. I think another distinctive practice of Justice Scalia's that has stuck with me is his practice of booking opinions. So for every opinion that the justice wrote, he would, before the opinion was circulated, he would sit down with all the clerk who had worked on the opinion, and a bound volume of a cart of all the bound volumes containing the opinions, every single opinion that was cited in the opinion he was working on, and he would go through one by one every single citation in the opinion and look at the text in the bound volume and make sure that he felt comfortable with the way that the opinion was being used. I think it goes to what Judge Collins was saying, that even though he was on the Supreme Court and he could say he could not follow a Supreme Court case, he was really committed to fairly describing, accurately describing, rather than kind of fudging what was going on in the case. And also that he thought kind of the buck really stopped with him. Site checking is sort of like the least exciting part of being a lawyer or a judge, but it was important enough to him to get it right that he was willing to invest the time to actually sit down and go through the bound volumes. I think bound volumes are a little bit of a thing of the past. We don't have those in my chambers anymore, but I think the commitment to being really precise about what a case says and not sort of over-delegating the work is something that's stuck with me from Justice Scalia.
Thank you, Judge Kovner. Judge Larson.
Well, thanks to everyone at AEI for having us on this panel. When Ed asked me to do this panel, I thought about, what were all the lessons I had learned from Justice Scalia? And there were so many. Some of them were just small things, like the grammar lessons. To this day, I will not use impact as a verb. I put it in an opinion once, and he said to me, there are two perfectly good verbs in the English language you could use. One is affect and one is effect. You are smart enough to learn the difference. Please do so. So, there you go. You will never see impact as a verb in my chambers. I struggled at the beginning when I first joined the Sixth Circuit on whether I was going to join opinions in which other judges had used impact as a verb, and I decided that I would let that go. What I wanted to talk about, though, when I thought about this audience, is the fact that we're now 10 years on from Justice Scalia's passing, and fewer and fewer people will have had the great pleasure that all of us did and privilege to just have spent time in his company. And when I think about how history is going to remember Justice Scalia, his words in the U.S. reports will endure forever, and generations of law students will read them. They're very important. He made great contributions to the law. His dissents, in particular, are very sharp, just as sharp as they are sharp-witted. But what I hope that history will remember about Justice Scalia is that he gave us all, at least those of us who clerked for him, really a masterclass in how to be a people person. And you might think that's kind of strange, coming from the great dissenter. I mean, he was sharp. I'll remind you of a few of his particularly good ones. So in 2015, in King versus Burwell, that was about the constitutionality of the Affordable Care Act. The majority interpreted a statutory reference to healthcare exchanges established by the state to mean exchanges established by the state or the federal government. Justice Scalia's dissent labeled this, along with some other interpretive moves by the majority, as jiggery pokery and pure applesauce. A few years earlier in Obergefell versus Hodges, he cast the majority opinion as lacking even a thin veneer of law, and then he accused the majority's methodology of having descended from the disciplined legal reasoning of John Marshall and Joseph Story to the mystical aphorisms of a fortune cookie. So, you might wonder, how is this the work of a people person? And as I thought about that, I have two answers. One is that Justice Scalia separated the people from their ideas, and the other is that he thought of them as all of a piece, which might sound like a contradiction. So I'm going to explain myself. So start with the idea that Justice Scalia separated ideas from people. When he was asked by reporter Leslie Stahl on 60 Minutes how he could be such good friends with Ruth Bader Ginsburg, the justice explained that he, quote, attacked ideas, he didn't attack people. Some very good people, he continued, have some very bad ideas. And if you can't separate the two, you gotta get another job. You don't want to be a judge, at least not a judge on a multi-member panel. Just so. But although Justice Scalia had a very pointed pen, he exuded personal warmth. His friendship with Justice Ginsburg is, of course, just the stuff of legends, but it went far beyond that. And I remember a day that I said something, I can't recall exactly what it was, but it was probably impudent and expressing some frustration with an opinion that had been written by Justice Brennan. Justice Brennan had retired from the court a few years before I joined the court, but we were bound by this opinion, and, well, I was frustrated. I don't remember what I said, but I remember Justice Scalia's response. And I take from that that I had crossed the people idea boundary. Because I remember what he said to me, and what he said was, Bill? He was all right. You know what I really liked about Bill? He always gave it to you straight and usually right between the eyes. And that takes me to my second point, which is that I think for Justice Scalia, sometimes the people and the ideas were all intertwined. What he really loved was the ability to joust. And when he saw a worthy opponent espousing what he thought was a bad idea, he took that as the opportunity to let it fly. Now, we saw that in chambers some. As others have said, he liked to let us try to spar with him. We didn't often succeed, but he definitely let us try. I remember the year I clerked, we had a case called McIntyre versus the Ohio Elections Commission. And this case was about whether the First Amendment protected a right to anonymous leafleting. And we all kind of thought that he didn't think it did. He thought the First Amendment didn't protect it, and he thought we were all First Amendment absolutists, and we thought he was wrong. So we came up with this very clever way that we were going to persuade Justice Scalia that he was wrong. And we started referring to the case as Publius versus Ohio, alluding, of course, to the Federalist Papers that were published anonymously. He greeted that with just the biggest, most uproarious laugh, and it was very, very gratifying to all of us. And he still dissented. But for the justice, that strength of the argument and the ability to argue, those who were willing and able to argue with him were the people that he held in the highest esteem. And so that, I think, accounts for the friendship with Justice Ginsburg, Justice Brennan, Justice Kagan, Justice Breyer, and really, I think, all of his colleagues on the Supreme Court. And I'm going to wrap it up not with my words because I'm not that good at it, but I'll use the words that Chief Justice Roberts wrote in the Harvard Law Review. He wrote that Justice Scalia, quote, thrived on the vibrant clash of ideas and took no offense from the din of divergent views. And he was also a man of lively passions, mirthful humor, abounding loyalty, and a generosity of spirit. He was, I think, a people person, and I really hope that history will remember it.
Thank you, Judge Larson. Judge Sutton.
Okay, it's great to be here. Thanks to AEI. It's great to be with all of you, friends, to share some memories about the justice. I guess I'll start with a grievance, really two grievances. One, this is my 23rd year of being a federal judge, and it's a very hard job. It really is a much more difficult job than I thought it would be. I thought it would be an easy adjustment. But I tell you, it's a job where there's always something lingering, just something you're not sure you've got right. And I partly blame the justice. I think he made it a harder job. I think it would have been so much easier not to worry about consistency, getting it right, tracking everything down, and then all the wordsmithing and polishing. I'm obviously grateful to him, but I must say, as a judge, and I'm sure everyone up here appreciates this, it's a hard job, and to do what he did for 30 years and day in, day out, on the little opinions, the big opinions, right the way he did, I just have so much admiration for him. You know, good for you, Joan, on putting a positive spin on the grammar obsession. I think we should call it what it is. I mean, I'm told that his father was correcting his D.C. Circuit opinions, and so I think this was, to whom evil is done, does evil in return. And he was doing the same thing to us that his father had done, and it took me about too long after he died to come up with a great comeback when he was correcting my grammar, and of course he had too many opportunities to do this, but I'd use citation to as opposed to cite, and it's just a classic one he would tell you about, and I just wish I'd had the presence of mind very quickly to say, no, Justice, in this setting, what would be the right use of the word pedantry? I really think he would have enjoyed that, and it would have been quite an accurate comeback. Something I got to see firsthand, this was after I'd become a judge, and we were doing a moot court at George Washington Law School, and after the moot court, it was really fun to see him in a kind of a small setting just with the GW professors. And he got up there and he said, when I went to start teaching at UVA, I was really excited about some of the articles I was going to write, and initially I had this attitude that the students were getting in the way. I mean, I had to prepare for class. I had to have office hours, and this was getting in the way of my precious scholarship. And he said it didn't take long for me to realize that the best articles I ever did had a shelf life of 5 years, But if I really lit a fire under somebody, that was going to really make much more of a difference. And it's interesting to think about that attitude he had towards teaching, and then think about him as a judge with his law clerks and his opinions. He lit a lot of fires. It's really remarkable when you look at his law clerks and some of the things they've done. And the common denominator, if you ask me, is not what they'd done before they went to his chambers. It's what happened after. And he was just such an inspiring individual. He brought so much energy to everything he did. There was no such thing as a boring case. I won't say his opinions will have anything like a shelf life of 5 years, but time does move on. It's really interesting to think 50 years from now which opinions of his will still be read and remembered, and it's not as many as we think. And I really think the greater impact he's going to have on the law is the number of people he inspired to think critically, try to get the right answer. And already, just 10 years after his death, the issues are already changing. And I really think he had a great insight about this as a teacher, but I think it applied to him as a judge. I'll give you one example of his passion, which at the time I thought was a bit bonkers. We were towards the end of the term. I'd written a draft opinion for him, and he calls us into chambers, and he seems to be in a good mood, and he's dramatically prints out the draft opinion, and now he starts to give us a dramatic reading of this dry as dust opinion. I thought, end of the term, I think it's getting to him. Like I said, hard job, and I guess there was another feature of this. He had so much pride in what he'd done, and I was always taught you hide your pride. You don't brag. You don't advertise how great you think you are. Well, none of this mattered to him. I mean, you would have thought he was reading a Shakespeare soliloquy. He would pause. He would gesture. It had given him so much joy to write the way he had. I mean, when I think about what made him such a great writer, I really do think part of it was just the joy it gave him. I mean, he cared, obviously, about the craft, but that really, really stuck with me. And, you're this young, impressionable lawyer, and you're thinking, wow, writing, I guess, really is exciting, and I really should try to put something into this. So as a young, impressionable law clerk, that was just, hard to top. One thing just to mention, just to give you a sense of how much things have changed, I had a due process case I was working with him on. Don't end a sentence in a preposition, he would have said. And none of the parties had briefed the history with respect to how due process might apply in this instance. And of course, we knew as Scalia clerks, well, we have to look at the history. So I'm out there reading these early 19th century, late 18th century common law opinions, trying to figure out. And this was not an easy task for a young lawyer, and even for a very good lawyer, which I was not. If you think about this today, there is zero chance you would get a case at the court that wouldn't have 5 to 10 history briefs on any problem that remotely related to the meaning of the Bill of Rights, a 1789 provision. So it's remarkable how much he just changed the practice of law. I mean, everybody has to speak that language today. You can't get anywhere if you don't. You can see Heller. You can make the argument that the originalist theory doesn't apply, or that's not the right reading of the history. You can do any of those things, but clearly you've got to do that. You've got to come to grips with the history, and that was not true in 1991-92. The last two things I'll say, and I guess one definitely is speaking as a judge, but I just so admire this about the justice, and I just think it's so critical to what being a good judge is about. Scalia left a scorecard for himself. I mean, you can decide to focus on his dissents where he's disagreeing with that person or another person, or this majority opinion, whether you agree with it or not. But what I love about Scalia is you know how to judge him. And think of how few judges and justices in history leave that kind of record. I mean, usually it's, do I agree with this? Do I like the outcome? That has been our conventional approach to what we think of judicial opinions and U.S. Supreme Court opinions in particular. And it's really quite remarkable to me to see plenty of people now trying to say, oh, Scalia got this wrong because he got the history wrong, or Scalia got this wrong because he got the text wrong. He wouldn't have enjoyed that, but he would have appreciated the facts that they were arguing on his terms. They were judging him by a scorecard he had from the outset. You could judge him every term of the court, and you can judge him still. And it seems to me, I don't understand how you can take the oath and not leave for others the way to judge how you're doing and whether you're following your oath. And he did that to a T. And the last point is just, I guess it's kind of where Joan was leaving off. It's really wild to think of what he would think's going on today. I mean, I can't tell you the number of times I've wanted to just say, I've even called Gene and said, Gene, what would you have thought about this? And Gene's answer one time was, he was said, that's your problem, which I kind of like that answer. That probably is true. It is our problem. But I mean, what would he think of, major question? He joined some major question cases. What would he think about the non-delegation debates? What would he think about the emergency docket, national class actions? It's too bad we don't have him. But we have a lot of people left that cared about getting it right, and I guess that's useful, and maybe that'll help us answer these questions. But it is kind of I guess we're celebrating his death rather than his birth. I don't know what AI was thinking there. But if we are going to celebrate a death, we should remember mortality, and even Justice Scalia is not going to be there forever, and maybe we can apply his principles, but we do have to figure out how to sort out some of these problems.
Thank you all so much. I have just a few questions before we turn it over to a few questions from the audience. My first is about, what, if anything, you do differently as a judge than, you saw Justice Scalia do when you were his clerk. For me, I've been thinking about this a bit recently because I think, there are some respects in which too much imitation can be a bad thing. In particular, very few people, and not me, have Justice Scalia's ability to write sharply and humorously, and sort of, incorporate a good amount of spice into his opinions. And as I write my own first opinions, I've been reflecting on, I have this sort of impulse to imitate him, but actually, I'm not sure I can pull that off, and many can't. So that's one way in which I've been thinking about the differences. And so I'm curious, what, if anything, you all do differently from him? I can start with Pat, and then anyone else can take it from there.
Well, I'm a district judge, so everything. I do everything differently than he does. There's a couple things I do the same. Like I'm the only judge on our court that doesn't have bench memos. I've never had a clerk write a bench memo for me. I read the briefs myself, take notes, read the cases being cited. It takes me a long time to prepare for a hearing. Yeah, we didn't do, I don't know if later years he went to bench memos, but we never wrote bench memos for him. He used to say, I read the briefs, why do I need a 26-year-old to tell me what I just read? It's a good question, actually. So I don't use bench. I also, in Minnesota, we are a rare district court in that we have oral argument on all dispositive motions with rare exceptions. And I have oral argument as much or more as my colleagues do, because I find that very helpful. So there's a lot of ways that it does carry on. One thing that I should mention, given our current times, is he really didn't. He never ever made a decision based on what the New York Times would think of it, or what the media would think of it, or whether it would make him popular in the halls of Harvard Law School. He really, and he didn't have a lot of time for some of his colleagues for whom that wasn't true. And we don't, as district judges, we have a case every few years that tests that. We're being tested right now in Minnesota with that, but that ability to honestly apply the law in high-profile cases the same way you do in any other case, and then go home and sleep well because you know you've done your job as a judge. I got that from him. A couple of things we do differently. Our jobs largely have to do with facts. It largely has to do with finding the facts, deciding whether there's a factual dispute, I mean, there's I spend a lot of time taking guilty pleas. There's just not a lot of, I often say judicial philosophy is for appellate judges. I don't have a philosophy of taking, you take the plea. And the other more important thing I think is so much different between my job and his is so many of the decisions I make, there's no law that tells me how I have to make that decision. I'm told act reasonably, whether something's in good faith. When we sentence people, we sentence them under 3553A, which tells us that we're supposed to impose a just punishment. Like we needed to be told that, but a just punishment. So we have, when Rachel or I impose a sentence, you have enormous discretion in imposing that sentence. You won't get flipped. And what you end up deciding on is it isn't parsing what somebody in 1789 thought something meant. It's judging another human being. And I don't think he would have been comfortable doing that. We often asked him, well, are you going to go try a case in the district court? And he always said, no, I'd be terrible. I'd be a terrible district judge. And he would have been. He would have been a terrible trial judge. So in that respect, I think in those two respects, my job's the most different. I don't know if you agree. You're the other district judge on the panel.
Yeah, I mean, for sure. And I think, Justice Scalia was, some of the other panel speakers alluded to, writing often for law students. He was very aware that his audience as a Supreme Court justice was a broad public audience and sort of a generational audience. And for us as district court judges, it's often, the parties in that case, they want to know how the case came out and why you didn't accept their arguments and you bought the other side's arguments. And it's not going to be, in the New York Times. So I think the style that's appropriate when you're really talking to the parties about something that's of great importance to them, and really probably nobody else is going to engage with, is probably different from Justice Scalia's style. But also Justice Scalia's style was so authentically Justice Scalia's style. I think the controversy about some judicial opinions now that sound like Justice Scalia is, maybe that's not actually their authentic voice, and maybe the influence of Justice Scalia has led some people to write in that voice when it's not necessarily their voice. So it's not, I think, my default voice, and I'm not sure I would be a very effective, just in the tone of Justice Scalia writer.
Well, I'll say, Rachel mentioned that each opinion before it went out, he would book with the law clerk and have all the cases right there. And I started doing that when I went on the Court of Appeals, and I gave that up very quickly. We have a lot. You're writing 70 opinions a year, and the hard cases, I was looking at I don't want you to think I was doing judicial malpractice, but it really took a lot of work. And, good for him that he was so careful about it. But boy, I could not do that as a Court of Appeals judge. Now, I will say, Pat, did he do that on the Court of Appeals? Did he book cases on the Court of Appeals?
Okay, so
now, the D.C. Circuit doesn't decide any cases, but still, I'm curious what he did.
He booked cases in the Court of, but he wasn't looking up every single site in those opinions. If you he wanted us to be afraid that he would look at every single citation, but. When you say when you cite the standard for summary judgment or something, he's not flipping through to make sure that's correct. But he did book them in those days. And when I clerked for him, we didn't have Westlaw or Lexis. Did it come? I don't know what year people started using that, but we didn't have a computerized electronic research.
No, he wouldn't ask you to. He wouldn't look at the quotes. I remember him saying to me, Jeff, you can get the quote right. I think. Thank you. Wow. The second thing he did, which was easily one of the top 5 highlights of clerking for him, is he would have these clerk conferences where everyone would just, debate quite carefully, vigorously, rigorously what the right answer was. And you learn very quickly as a Scalia clerk that he wouldn't respect you if you wouldn't disagree. So the first way to show that you were worth taking seriously was showing you could disagree with him, and that made those conferences really fun. So I started doing that with all of my cases at the Sixth Circuit, and again, it just took too much time. But I still admire him for doing what he did, because surely there were plenty of 9-0 cases he didn't need to do that. and he would still do it with us. And I found myself saying, I just can't do this. So anyway, those are two things I've not adopted.
Well, I actually still do it. I still do the booking, but I've made it electronic. So I've made it very fast, and I'll show you some of my methods. It'll speed the process up for you if you want to try that.
Go ahead, John.
Yeah, I definitely do that. That part of the culture, once you learn it that way, you just cannot unlearn it, and you can't do it a different way. And that's, I think, you mentioned the kind of the curse of the clerkship, that you're taught at a level of rigor and excellence, and then once you see that, you cannot go back. And so absolutely, I mean, I don't think the justice ever told us directly, you need to come and disagree with me. That was sort of understood. But I do tell my people, you do need to do that. That if you think differently, you need to come and say that. I may disagree with you and we'll have it out, but I need to hear that from you, and that's your job. And I feel like, that's not how everybody approaches this work. That was a kind of Scalia quality that I feel I'm now, for better or for worse, the heir to. That's just how he ran it. And so you have to get used to that. And, the justice had he had a very thick skin. I mean, he was used to being criticized, and I learned a lot from him from that perspective as well. Just to how to take criticism from others, from other colleagues, in the press, wherever, and not let it faze you. And that was another great quality of his.
All right, I'll ask one more question, I think, and I warn you, this is not one that I, sort of sent you before, but I was thinking about it during the last panel. And at least, when I was in law school, I think perhaps sometimes less so now, one of the main theoretical justifications for things like textualism and originalism and, rules rather than standards was judicial restraint. The idea of basically keeping judges in line and keeping their own personal values out of it, rather than a sort of common good or morals-based approach. And my question for you is whether, as judges, you have subjectively experienced those doctrines as, in fact, imposing judicial restraint in deciding cases. And I guess this is probably more a question for the courts of appeals than the district court judges. But I think it's interesting to see sort of how that philosophy bears out in practice.
Well, if I could just say one thing about people kind of say, oh, Scalia's Bork, and they were all about restraint. But I hate using that word as a way of thinking about a judicial philosophy, because I don't think that's really what he was thinking. I think it's very important to think of it as pure separation of powers. That's what he meant. And it was that there are things judges do, they read law, they're good at reading law, there are things they're not very good at, and that's what the judicial power is. And if they're within the judicial power, there's no restraint to it. I mean, Crawford, the Confrontation Clause case, it's one of his favorite opinions. That messed up Confrontation Clause law. I mean, it started everything anew. They had so many cases after that. There was nothing restrained about that at all. I mean, every prosecutor in the country, state and federal, now had to think anew about how to do this. And so, to me, I think of myself as a restraint-driven judge, so it's not like I'm offended or triggered by the word. It seems like it, obviously, but I really think it's not fair to him to think of it that way. I think it's a pure separation of powers point, and if what the original public meaning was applies, you're actually abdicating. You're not upholding your oath to honor the hierarchical, the superior law, the Constitution.
One thing that we've had a lot of cases dealing with COVID restrictions, and I've often wondered in approaching those, and I've written, some majorities, some dissents, some of my majorities, one en banc. I wondered what he would have thought of those cases, and maybe I know the answer to that because he was so intellectually consistent. And maybe he would have said no unenumerated rights. He said that in Troxel, no unenumerated rights, and that's it.
And maybe he would have said no unenumerated right, to leave your home. And maybe he would have taken the hardline position. But I wonder whether those would have pressed him. Maybe he would have thought differently about the cancellation of jury trials. I wonder how he would have approached that. And in confronting some of those cases, I often thought, gee, I wish I could talk to him and know what he would think of those.
Okay, I'll ask one more. I know that I said the last one was my last one, but I lied. At least when I applied to be a Scalia clerk, and I think that's true for at least many of us, if not all of us, the process was very taxing. I was, subjected to an hours-long, rigorous grilling from the previous year's clerks about various obscure and difficult areas of law. And it was sort of a, game of not saying anything too profoundly stupid, I think. And I'm, that is not so far, at least exactly how I've gone about clerkship hiring. And I'm curious whether you all see yourselves as sort of following the same mode of hiring law clerks as Justice Scalia did, or whether you've, deviated in that regard.
Well, I do it. I don't do it. When you went to interview with Justice Scalia, you spent like the first half an hour maybe with him, or an hour if he liked you a lot. Mine was probably half an hour. It was very informal. I think he asked me like maybe one legal question, and then he just asked a lot of questions about me and where I came from and what my parents were like, and you wanted to get to know you as a person. And then he fed you to the wolves, and you went to interview with the clerks, which was a very taxing process. I kind of do the same. I'm pretty gentle on the law clerk applicants in the interview with me. I do ask them a couple substantive questions, but not that many. And then, I have my law clerks try and figure out because a lot of this job is instinct, but it's instinct built on a foundation, right? And so if nobody laid the foundation for you, then you're not gonna have good instincts to lead into the places where there is no law. So I have my clerks try and figure out whether there's a solid foundation there or not.
Since we have to hire clerks when they're in the 6th grade, they don't not as fluent in the law.
We could stop that if you'd stop hiring them so early, Dan. No, I'm kidding.
John Sauer interviewed me. I interviewed Adichie Bomzai, who's here, and so you kind of laugh about it later, but at the time it was pretty painful. I remember my interview. I drove up and I parked at Union Station. I think I got there like pre-dawn hours, and then I had 5 hours just to like read things, and it was like a deep throat. So I got out of the interview and I came back to my car. I guess I didn't realize there was paper everywhere. There was law review articles. There were printouts of cases. A paper bomb had gone off inside the car. I think there was value to it, and what, among other reasons, though, I think what it tested, and I do this, as does Judge Larson similarly, is that, you had to be prepared to disagree with the justice. And it was hard to go into the justice's office and tell him that he was wrong. Or he would call you on the phone and say, why'd you say this? In the draft. And you'd have to say, well, no, here's why I said this, and be willing to tangle with him. And I think that it did find out if people could go through that process. And I think he wanted that. Although I don't recall him giving us great direction on that part of the process either. That was just also sort of an understanding.
I thought that was, what you'd been subjected to, you yourself subjected others to in the future, like the grammar.
So I interviewed with him a year after he was appointed to the Court of Appeals. They didn't do that then, thank goodness. I was not asked a single question about the Dormant Commerce Clause while I was interviewing. I came, the way this will be in a confirmation tales, fairly new futures, but So I was at Harvard. It was fall. Everybody said it's time to apply for clerkships. You need a reference. I didn't know any of my professors at Harvard. I went to Clark Bice, who had Scalia as a student in 1960 or so. And I said, Professor Bice, you're not going to remember me, but I like you the best of my professors. Would you be a reference? And I don't know if I can do that. And he and I realized later he actually was interviewing me without me knowing it. But he said, well, let me think about it and I'll get back to you. And I walked back to Gannett House where the law review was. And the receptionist told me, Professor Bice is on hold waiting for you. And I thought maybe I left something in his office. And I picked up the phone and he said, Judge Scalia will see you tomorrow in DC if you'd like. So that's why you go to Harvard Law School. I couldn't actually get there the next day, but I went there a couple of days, so I didn't have time to read all those things. I didn't know how to pronounce his name. All I knew, and we didn't have Lexis and Westlaw then, so you couldn't look stuff up like that. So I went down there and we, as Joan described it, we just talked about kids and faith and raising kids and just hardly law at all, really. And then at the end of my interview, he said, all right, I really want you to clerk for me. I think we'd be a really good match. But I'm afraid if I offer you a job, you're going to think I'm desperate. So if I want you to clerk for me, should I offer you a job or not? And we talked it through. And we came to the realization that for me to clerk for him, he would have to offer me the clerkship. And he did. So it was different in my day.
Yeah. That sounds very nice. We have just a few minutes for questions from the audience. If folks want to just raise their hands, I think there are microphones around too. Maybe right over here.
Yes, thanks. My name's Alan Parker. And, I don't like the justification necessarily for originalism that's as a restraint on the justices. I think that in the early days that may have been very appropriate because we had a very unrestrained judiciary, but the proper purpose to me is justice. In the Declaration of Independence says we have these certain rights, that governments are instituted among men to secure these rights, and that deriving their just powers from the consent of the governed. To me, originalism is very much a just powers concept, that the judges are doing the right thing by interpreting the Constitution that the people adopted according to the public meaning of the words at the time. Was that very important to Justice Scalia, or a justification for why he didn't want to just do his own values? That's kind of my question. Y'all know him well. Sort of in honor of the 250th year of our Declaration of Independence.
That's an appellate judge question.
Well, I mean, let's be clear. He loved the Declaration of Independence, but I don't think he thought of it as law. And, that's where he was a positivist. I mean, I think that was the point John Yoo was making in the last panel, that he really, and it might, you really wonder how he would have thought about some issues today. But when he came of age, he really was responding to a world in which the D.C. Circuit and the U.S. Supreme Court were, let's just say, very flexible with statutory and constitutional interpretation. And he thought that was a separation of powers problem. And for what it's worth, Cam, for all the successes he had before he passed and since he passed, there still is no country in world history that does what we do. Unamendable Constitution, interpreted by life tenure judges, and they do it all the time. So you can't get rid of them, and you can't correct what they've done. The footprint of the federal courts, there is nothing like it in world history. And even though he's had so many victories, that is still true. So judges doing justice, I mean, I want that. It's not as if I don't want that, but I think the Declaration of Independence, frankly, was more about democracy functioning, and I actually think that's our big problem right now. I think the judges are doing just fine. Maybe we should go to work a fewer days, but when we are at work, we're doing a good job. But it's the fact that we can't elect representatives willing to compromise or or do what they're supposed to do. And I think the people that wrote the Declaration of Independence, that would be what would upset them most today. It would not be the performance of the courts.
Yeah, over here.
So I have the privilege of serving as the Director of Judicial Opportunities for FedSoc at Georgetown. With 7 of our finest judges in front of us, it would be malpractice not to ask a 2-part question. We sort of touched on the first part. What did you learn from the justice that you use when you're looking for clerks? Sort of touched on foundation. And more importantly, what do you hope to pass on to your clerks?
Thank you. I think I've only hired a few years with a clerk, so I am by far not the expert here. But I think a few things. First, the justice. I remember when he interviewed me, we got into like a little debate about something, and he kind of sat back for a second. He looked at me and he said, "You know what, Miss Krause?" That was my name then. "You're very flinty," and. And at the time, I had to go home and look up what that meant. It turns out it meant all the things we've been saying, sort of, being up for disagreeing with him. And so I look for flintiness. Now I think about that every time I interview a law clerk. And I also look for, and this was, this is like Judge Collins saying, I look for honesty. I mean, he was so honest about what he actually thought and what the law actually says. And I think, as Judge Kovner was saying, one of the, so far in my experience, downsides of this remarkable privilege is that, of being a judge, is that people are often just telling you what they think you want to hear, even if that is not what they honestly believe. And that spooks me a little bit, and I think it's because of my experience with Justice Scalia. So I'm looking for honest, flinty people, I guess.
So I went through 3 sets of clerkship hires with him, because one of the sets we hired for the DC Circuit, after he went on the Supreme Court, he had to, I won't go through all that, but 3 sets. And I wasn't responsible for bringing him like 10 or 20 applications that he would look through. My 3 co-clerks were all smarter than me, but they weren't very practical. And so they'd lose things. And so he had me organize the clerkship thing. And I remember when we were at the Supreme Court, we got an application from someone who was first in his class at St. John's. And he was the editor-in-chief of the Law Review. And on paper, he looked like a perfect match for Justice Scalia. He was devout Catholic, just everything. And the justice wasn't going to interview him, and I pled with him to just try him, see what you think. So he came down and he interviewed. And he didn't get an offer. And what Justice Scalia told me is, I can't make a mistake with a clerkship hire. I got 4, and if one of them isn't working, it's like a flat tire in a car. I mean, it affects the other 3 clerks and me for the whole year. And I know this was back when Harvard and Yale and stuff had grades. I know what good grades at Harvard means. I know what being first in your class at Yale means, or at Penn means, or at Chicago or Stanford. I have no idea what being first in your class at St. John's means. It could mean that if you'd gone to Harvard, you would have been first in your class there, or it could meant if you went to Harvard, you'd be a B student. I don't have any way of knowing that. So it's all playing the odds. And he was not apologetic about basically hiring the best students from the best school. He didn't feel some obligation to reach out and hire from lesser schools. The exception he'd make is he said, if I know somebody on that faculty, or I know the judge they clerk for, the Court of Appeals judge they clerk for, and that person tells me they're as good as anybody from Harvard or Yale or Chicago or Stanford or wherever, then I'll take that. So that's why I've been kind of elitist. I've hired probably the fewest clerks from Minnesota of any of my colleagues, probably the most from out of state, and it's playing the odds.
Yes, do you have a question? Right there, the blue shirt.
Hi, thank you so much for being on this great panel. I'm an undergrad at Georgetown. My question is, I think all of you except maybe Judge Schultz clerked for someone else and then clerked for Scalia. My question was how that kind of interaction influenced your clerkship experience, what you got from Scalia and how you judge today?
Well, maybe I'll answer that because I clerked for two very different judges. I clerked for Judge Dorothy Nelson, a Carter appointee on the Ninth Circuit, and everyone would, when they would look at that and say, Nelson, Scalia, how do you put those together? They think either I'm a Scalia counterclerk or I was a Nelson counterclerk, and I was a Nelson counterclerk. I was definitely the most conservative law clerk that she ever had. But they were both academics at heart, and they loved the intellectual exchange of ideas within the chambers, and that's something that that I find very valuable and learned from both of them. But one important difference that they had, and Judge Nelson was open about this in her authorized biography, she would not always dissent if she disagreed. She would sometimes, it had to be a special reason to dissent. She would go along and join things that she actually had voted against. That was not something that Justice Scalia ever did. And I followed the Justice Scalia approach on that. So I will not join anything that I disagree with, and even a footnote, if the footnote comes out, or I'll write separately. But I learned from both of them the intellectual exchange of ideas, but I appreciate his insistence on always getting everything right and saying it publicly.
One thing, I was just add one thing that's really going back to the last question, but I think it's an important point. He almost always had a true intellectual diversity in chambers, and I've definitely tried to do that, and I do worry that that is not what's going on for most federal judges these days, that there's a fair bit of ideological hiring, and I just think that's unfortunate for everybody, the judges, clerks included. And I actually was not hired by Scalia. I could never have gotten through the clerkship process. No chance. I was hired by Justice Powell and was the 5th clerk for the Scalia chambers that year. But that was a real gift to me because Justice Powell and Justice Scalia really thought about the law and judging very differently. Justice Powell was a practitioner. He said no the first few times he was asked to go on the court. He had no interest in going on the court. He finally did it as his duty to his country at age 64, 65. So when he gets on the court, he's just confronting these new areas of law and just worried, trying to do the best he could in each case. He believed in balancing tests, very pragmatic. But what was a true gift to me as a young lawyer is for the rest of my career when I was out arguing cases and eventually as a lower court judge, I became pretty good at speaking both languages. So I was never in a place where I couldn't speak the languages of the panel because of those experiences. So it actually is valuable to clerk for different people the way Dan did. You're going to be a better judge if you've heard both sides of the argument.
Yeah, I clerked for Brett Kavanaugh before for Justice Scalia, and one thing that they both have in common was they just had really deep collegial relationships across their courts, including crossing ideological legal divides. And I thought that made them, great at their jobs, among many other things. And so I'm happy to report that the Seventh Circuit is also very collegial right across the court, and so following in that tradition. All right, we are going to call it there. Thank you all so much, and thank you, Ed.
If you judges would stay seated for just a second while I have some closing remarks. But again, thank you all. What a day it's been. What a wonderful afternoon. We have a full day tomorrow. Please join us for beginning with the breakfast conversation that AEI President Robert Doar will have with Danielle Sassoon. We'll have 4 panels on originalism and textualism. That's one. On the religion clauses, on administrative law, and on Justice Scalia, the writer. And we'll also have a great lunchtime presentation by Princeton professor Robert P. George. And please now join us in the reception that will take place right over here. Thank you.